Okay. Good evening. Welcome to the emergency special meeting of the Select Board. It's September 12th, 6 p.m. And we're here tonight at the Kappa location, which is in North Bennington. I apologize to anybody for whom this was an inconvenient venue move. We tried very hard to get it in the usual place downtown. We couldn't get it in the firehouse. We couldn't get it in any of our usual places, so Bennington College was nice enough to oblige us here for a couple of hours. Before we, Tom's recused. Tom's out on this. So before we start the evening meeting, I'd like to have everybody introduce themselves, please. Let's start with you, Jean.
Good evening, Jean Connor.
Good evening, Carson Thurber.
Good evening, I'm Jim Carroll.
Hello, I'm Jeannie Jenkins.
Good evening, Chad Gordon.
And I'm Stuart Bird, and I'm just waiting for any late numbers so I can handle it.
Okay. Nancy Ladley's with us. Meryl Bent. What's the name of your office again?
Wilmington, Campbell, Benton, Stasny.
Okay, thank you.
She's on the mic.
So we're going to hear from Meryl, if you're ready to present.
Yeah.
And if you'd give us the full rundown of where we are and what your suggestion is, please, that'd be great. Thank you.
Yeah, absolutely. Hi, everyone. My name is Meryl Bent. I'm an attorney and director at Wilmington, Campbell, Benton, Stasny in Manchester. We serve as the town council, and as many of you probably know, I've been involved in the Chelsea proceeding and related solar and litigation matters for several years now. So I just want to take some time to explain to everybody what's brought us here tonight and give some of the relevant history and most significantly the recent history of some issues that have arisen in the Chelsea Solar case. I'm going to assume that the majority of you are familiar with the long-range view of the matters because they've been around for some time, but I am going to touch on a couple of long-range historical points because they're relevant to the discussion that we need to have tonight. So, as most of you are aware, Chelsea and Apple Hill were solar projects proposed by some developers beginning in 2014. In 2015, there was a technical hearing on those projects, and immediately following that hearing, the town of Bennington submitted a brief explaining why the Apple Hill project was not in conformance with the town plan. That same brief was actually filed in the Chelsea petition that was pending at that time, which I'll call Chelsea 1, just for ease of reference. And ultimately, the Public Utility Commission, what was then the Public Service Board, decided that the Chelsea project did not conform to the town plan and denied a certificate of public good on that basis. So as everybody I'm sure is aware, around the same time of that denial, the Bennington Town Plan was amended to add some more stringent requirements for solar siting, and it was to apply to all future solar siting, all future solar projects. Fast forward to November 2017, Chelsea refiled its petition, and it significantly changed the project that it had originally presented. The changes that it made included a reduction in the scope of the project and a reduction in the amount of clearing that would be required for the project and some additional screening measures that would be part of the project. Because of the timing of the town amendment, the amendment to the town plan, and vis-a-vis the new petition, the town operated under the impression that the new town plan would apply to the project. That said, the town nonetheless reserved the position that it could take in the alternative under the old version of the town plan. And that assumption proceeded without any issue until March of 2018, when Chelsea filed a motion asking the hearing officer to rule that the old version of the town plan applied and that the new version of the town plan did not apply. The town vigorously opposed that position, but unfortunately the hearing officer agreed with Chelsea and determined that the old version applied. The town then took what is in the legal world a rather extraordinary step and requested an immediate consideration by the board because those issues were so important to the evidence that was going to be developed and presented at the technical hearing, and also to avoid a situation where it went all the way through one technical hearing, had that issue determined on appeal, only to do it all over again. Unfortunately, the town lost that motion, that appeal, and the Public Utility Commission has ruled that Chelsea is entitled to review under the old version of the town plan. So that really brings us to where we are today. It changes the landscape of the select board's prior determinations, and while it doesn't create a zero-sum game, it really requires some new consideration and some new analysis. And I know a lot of people are going to wonder, why not just proceed under the old version of the town plan? We've reserved the right to do that, and Chelsea 1 was denied under the old version of the town plan. But the fact is, this is a different project. And I just want to point out a couple of things that have made it clear that the PUC is taking that very seriously. The first thing is, in 2 very recent orders from the PUC, they have emphasized the fact that the project is much smaller. They've emphasized the fact that the project, in their view, is going to have less impact on surrounding properties. They've also emphasized in their decisions, including in a decision made on August 22nd, 2018, the fact that the decision in Chelsea 1 was limited to the facts that were in front of the board when it reviewed Chelsea 1. In other words, they're saying it's not precedential, and they could reach a different conclusion on the new facts in front of them with respect to the new Chelsea project. They also took pains to emphasize that their prior decision was based primarily on the fact of the prominent visibility of the project and on the fact that it would require 15 acres of clearing. So with all of that in mind, the select board has been placed in the position of having to consider what the options are. I think there's been a lot of vocal opposition to this project from the very beginning. I don't think that's lost on anyone. That opposition has in fact been presented to the PUC through strong townspeople who have very strong opinions on this and who've done a really good job representing their positions. But that's not the only consideration. The select board has to consider what the town plan says, how it's likely to be interpreted by the public utility, well, first by the hearing officer, and part of that is to look carefully at the language that the PUC has very carefully used in its recent decisions. The select board has to consider what the variety of opinions in the town, and they also have to consider the use of town resources, including taxpayer dollars, especially contrasted with the likelihood of success. So that brings us where we are today. I've talked to the select board at length on what their options are. They have a few options. I've talked to them about the options and the risks and the likelihood of success of each of those options and how long each of them will take and what they'll require. One of the options that we have in front of us today, what the select board has in front of it today, is a potential settlement agreement. And one of the hallmarks of a settlement agreement is it allows a litigant to have some modicum of control of the outcome. If you leave the decision solely to an administrative or judicial decision maker, that decision is out of your hands. So that's an important component of a settlement agreement because it provides some level of certainty. I'm prepared today to outline the terms of the proposed settlement agreement. The terms have been discussed at length between myself and Chelsea, and we've pushed them on the terms, and I think that Stu has made copies of the proposed settlement agreement. I did want to point out that the date on that settlement agreement is just the date that this version was finalized. It's not a date that any agreement was made, because there has not been an agreement made. There has not, in fact, been a decision made. And I want to also explain to you all the reason that we're here at an emergency meeting, because it's important that people take their time to consider these issues carefully, and I think the select board has done so, but we are running on a time frame, and one of the very important decisions that needs to be made is whether the town wants to prepare for a hearing that's taking place on the 20th of this month. It'll take an immense amount of work to prepare for that hearing, and our office is certainly not scared of performing that work, but it's a big undertaking and it's an expense to the town taxpayers. And the other reason that timing is important is because this settlement agreement may not last forever. The proposal may not last forever. It could be rescinded if Chelsea decides that it's undertaken its preparation for the hearing and it's ready to go. So there is some urgency in deciding something that could be gone if it's not acted on quickly. I really want to emphasize the point that this select board and this town has really worked hard on these matters. They've done a lot of work. The project is already significantly improved, in my view, from what it was originally proposed in 2014 and what was rejected in 2015 by the PUC. The town's raised a lot of issues throughout these proceedings. It's prevailed on a lot of those issues. The town has endeavored to coordinate and cooperate with other parties, including the town interveners who are citizens of this town. So, you know, a lot of work has gone into it, but the select board is now facing a reality that it very well may proceed with this, spend a lot more taxpayer dollars, and come away with absolutely nothing. So that's a consideration that needs to be made. And I'll plan to go over the terms of the settlement specifically in a few minutes, but for now I'll turn it over to the select board in case there are other points they want to make before we do that.
I would, the sequence I'd like to try to go through here, Meryl, if possible, and this would be with the board's consent, would be to have you give us just a little bit more on the three options that you laid in front of us.
Sure.
And the likelihood of success. And then I would like to hear a blow by blow on this settlement agreement,
Sure.
which you have done with us, but would like to have it again. Mm-hmm. And then we'll take it from there.
Okay, that's great.
And I'm going to ask everybody, including the board, to hold questions until we get to the end of what you have to say, please.
Okay, great. So the other options that we have gone over and discussed with the select board are number one, the option to actually ask for review now by the Vermont Supreme Court of the vested rights issue. That's a discretionary decision, so we can request it, but we don't know if that would be granted. So while we waited for that decision, we'd still have to prepare for the hearing. If that request were denied, the town could then proceed through the hearing based on the Old Town Plan and continue to oppose the project on that basis. In which case, following a decision, the town would have a right to review by the Vermont Supreme Court, including on the vested rights issue. If the town then appealed and won on the vested rights issue, it would then have to go back and relitigate the same thing, the same project under that new ruling. And if the town lost that, it would be game over. The second option that we discussed was, well, I mean, they're really interrelated because the second option was simply to forego requesting an immediate appeal, or what we call an interlocutory appeal, and go straight to the proceeding, which would then have the same result I just described, with appeal rights and the potential for re-argument of the entire project, depending on the outcome of that Supreme Court decision. Did I leave anything out of that? I think that covers it. So just to go through the terms of the settlement agreement, which I think you all have a copy of. Under this proposal, the town would withdraw its opposition to the Chelsea project, and it would withdraw as a party to that proceeding, and it would withdraw as a party to the Apple Hill proceeding. The developer would release the town from legal claims it might now have concerning both of those projects. As I'm sure you're all aware, there's pending litigation concerning those projects and the validity of various town provisions that apply to them. So under this agreement, several claims in that now pending civil lawsuit that don't relate to Chelsea would also be withdrawn permanently. And the developer has also agreed to seek no damages against the town through those suits. Period. The developer will agree never to develop, I'm sorry, never is the wrong word. The developer will agree not to develop the apple orchard up on Apple Hill into any use other than its now existing use during the life of the Apple Hill and Chelsea solar projects. Oh, I'm not going through it like I probably should.
Yeah,
but-
it would be good to go sequentially. Once you
Yeah,
start
that's
one-
fine.
And I apologize for asking you to redo this, Meryl, but for the sake of everybody in this room, why don't you start at one and just go right straight down the line.
Okay, all
Okay,
right.
so second page, number 1.
Second page, number 1, yes. So this
It
is,
starts with therefore.
Can we start on the first page?
well, that doesn't really have any specific provisions. That is just a series of recitations of the procedural history. So those aren't actual settlement terms. It's really legal boilerplate. I mean, it's specific to this project, but it's just a recitation of the history. So the terms start on page 2 and number 1. So the first one is the one I have already discussed, which would have the town agree not to oppose the project and withdraw as a party, and submit a letter stating that they've settled their disagreements and don't oppose the Chelsea project. It would also state that the project is consistent with the town plan in effect in 2014 in the town's view, and that is limited to the version of the town plan that was in effect in 2014. It would also agree not to appeal any decision made by the PUC in either of the Chelsea or Apple Hill proceedings. Number 2, the developer will reimburse the town in the amount of $202,250 for legal fees and staff costs. That constitutes legal fees as well as a portion of the staff costs that have gone into this project to date. The developer and all of the other entities that it can concoct and come up with will release and discharge any claims that have to do with the Chelsea project or the Apple Hill project. So that's one that I have already that I'd already mentioned. Number 4 is the one that says that the developer would release the town would drop several now pending claims in the civil lawsuit, and that they would seek no damages against the town through those suits, and they wouldn't bring any new claims on the same subject matter. Number 5 just states that the parties agree in good faith to extend any applicable filing deadlines in the lawsuit until such time as a final report, which is discussed below, is received. And the reason for that is if there's going to be there will be some need for delay in order to figure out which route the town is going to take, or the proceedings are going to take, so which I'll explain in more detail in the series here. The town will withdraw its cross appeal that's now pending in front of the Vermont Supreme Court. The reason for that is because if the payment is made, it will cover. It's a cross appeal for fees, so that would be covered by number 2. Number 7 is the one that I discussed about not developing the apple orchard into any other use than its now existing use during the life of the Apple Hill and Chelsea solar projects. It also says that they don't have any obligation to maintain the current condition of the apple orchard, so essentially they have the option to just let it grow. The number 8 is sort of a side issue that relates to the Battle Creek 1 solar project, and it's just an agreement to a reduced setback of 10 feet to allow Carbone Auto Group to have some additional parking because they're facing a parking issue. So that was really to benefit a specific Bennington business, and to, basically just to agree to waive that issue. So with respect to the landscape mitigation plan of the Chelsea project, which is the mitigation plan that they've proposed already to the PUC, they agreed to conduct post-construction review with all parties, and I'll explain what this all means, of all proposed mitigation plantings, and agrees to add additional plantings on its property to ensure long-term screening if and as necessary in accordance with such mitigation plan. So what that means is if it turns out that the screening doesn't seem to appear to conform to the mitigation plan that they presented, and it seems to depart from that, they are willing to come back and address that with all parties so that they can make some additional plantings in order to screen that off. So number 10 is it concerns what have been alternatively referred to as Battle Creek 2 and Battle Creek 3 projects, which are sometimes referred to as Stark and Warner. So this is an agreement that the town and the developer will identify an aesthetics expert to perform a review of these projects to determine whether they may be considered to be located on a preferred site, as the term is defined in the town plan. So what that means is it's a third party who has no connection to the town and has no connection to the developer, but has expertise in the specific area of aesthetics analysis, who will review the proposed project and review the Bennington town plan and determine whether that project qualifies as being within a preferred site. So the developer ultimately will own that work, but the town and the developer will decide together who that person is going to be. So then if the aesthetics expert comes back and says, yes, these projects can qualify as a preferred site as that's defined in the town plan, then there's a series of actions that will result from that. Number one, the town will not oppose the Stark or Warner projects, which makes sense because if they're on a preferred site, then theoretically they are in an appropriate place and they're adequately screened. So the word not to oppose means they waive the 45-day notice requirement and submit a letter to the PUC stating that they comply with the screening requirements of the town plan, of the solar screening ordinance, and that they are located on a preferred site in the town, which will, like I said, would have been the decision of the aesthetics expert. That they comply with the land conservation measures and specific policies contained in the town plan, and that the town will not intervene in the PUC proceedings for those projects. Implicit in this is the fact that the projects as proposed to the aesthetics expert have to stay the same. They can't change them after the aesthetics expert has ruled on them. With respect to the Warner project, the town agrees to a reduced setback of 10 feet along the western side of the Warner project parcel, and a reduced setback of 40 feet from the edge of the traveled roadway on Rice Lane on the northern boundary for the Stark project parcel. That doesn't mean that they're agreeing to that as a buffer. So again, if this aesthetics expert does rule that that these are considered to be or qualify as preferred sites, then the developer will release all of the claims against the town for any other claims that it might have. And then the developer would also agree that it will not develop any future solar facilities above 150 kilowatts on any areas unless they are within mapped preferred site areas identified on the energy amendment and as which the town approves under the solar screening ordinance, or specifically approved by the town and as to which the town approves specifically under the solar screening ordinance. The developer will also withdraw the pending lawsuits with prejudice, so those lawsuits will go away as well. And then the rest of these provisions are boilerplate. I'm happy to go over them if you want. They basically make representations about the respective parties' authority to enter into the agreement, that the agreement is governed by Vermont law, that they'll carry out, that they'll basically cooperate with anything else that needs to be done in order to affect the terms of this agreement, that it can be executed in counterparts, and that it can be emailed, that's just for the sake of efficiency, and that it may be amended only by writing specifically for that purpose and signed by both parties. And then the last term is that either party may file the agreement with any agency or court. So that's a rundown of the basic terms. I know that that's a lot of legalese, so I know that we need to probably unpack some of those for people. Yes?
Before we go into questions, I would like to ask the board. So we're going to go into board questions, and we're going to go into questions from the general public. And
Okay.
we'd like to have you available for that if possible.
Okay, that's fine.
But I guess I'd like to ask the board how we proceed at this point. Is there a motion, or is there some sense of which direction the board would like to go?
If we make a motion now, then we would have discussion afterwards.
That's right. So, but we would be focusing our discussion on whatever the motion pertained to.
I see, in terms of which option.
I'll put it.
How long does the board have this document?
We went through it in extensive detail in executive session on Monday. So, okay, so board, we have three options in front of us that have been put in front of us. What
So
should we be?
I'll put a motion on the table. Motion to move forward with option 3, reviewing this with the settlement agreement.
Okay,
I'll second.
second from Chad. All right, motion's on the floor, so we will be discussing the settlement agreement, I guess, and we'll be sticking with the
The third
settlement.
option.
The third option, yeah, so the third option, which is,
So they didn't.
Do we need a review of the 3 options? That's the one thing you guys don't have.
sure, yeah, the first option was to go to the Supreme Court and
Well, to request leave.
to request an interlocutory appeal to the Vermont Supreme Court on this issue, right? Would you-
Right, yep.
I shouldn't be, you go ahead. and-
Nope, that's right.
Okay.
And then the second option is to simply proceed based on the hearing officer's ruling that the old version of the town plan applies, and present evidence at the technical hearing based on that version of the town plan.
And then option 3 is what's,
Option 3 is to work towards some sort of settlement, right? Okay, so, let's do discussion from the board first. Yeah.
Because you skipped over that option 3 very quickly.
Okay.
don't, please.
I'm just trying to say, so is option 3 to have a discussion about this agreement as opposed to actually agreeing to it, and there would be public input into that discussion?
There's a motion on the floor, and it's been seconded right now to accept the settlement agreement.
That's not what I heard. I heard it was to enter into discussion regarding the settlement agreement. It seems to me that you have to have public input regarding the settlement agreement before you vote whether
We will.
to settle.
We will.
Accept it.
We will have that. Yep. So we will have board discussion. So perhaps I misunderstood your motion. Would you restate it, please?
Well, if it's mandatory to have the discussion, I mean, I don't want to pretend I know the answer to it, because I don't.
We are going to have discussion, yes.
Right. So I can put the motion on the table to say one of two things. I can say, do you want to have discussion on this? So I put a motion on the table to accept option 3 covering the settlement agreement.
Mm-hmm.
Chad seconded that,
That's what I heard.
and now we're having discussion.
Is that what you heard, Nancy?
Yes.
Okay. So we will now have a discussion about the settlement agreement, and I'm going to start with board
That doesn't
questions.
sound satisfactory. Let's,
Still confused. I
Okay.
think it's
please,
inappropriate
we're small enough group too.
to jump right to a motion to approve this settlement agreement without having discussion about it first. There are some questions regarding the settlement agreement that, are unanswered, and I don't know whether you guys have answered them in your discussions, but for one thing, one glaring thing, well, it says that if the Stark and Warner projects are located in a preferred site, then they get the green line, but it's absolutely silent about what happens if they're not in a preferred site.
So let's have that conversation.
Right, I mean, so Peter, I think I'm hoping that what we just said we would do is that we have a motion on the table to accept this. Now we'll have discussion, and then based on that, we'll decide whether to accept the settlement or not. Is
That's-
that accurate?
That's
It's not clear whether you will be able, whether you are going to be taking into account our concerns, such as Peter's. I have a big concern here that you've embroiled Apple Hill Association into, and whether you will be willing or able to amend this. That's what I'm.
So Laura, I think it's either we say, yes, we're accepting it, or no, we're not. And if there are concerns about, I think if we have concerns about the settlement agreement, then we would vote
No.
no.
Yeah.
And then we would go back, we would send you back to the table to discuss that. And if after having discussion, we decide that this is what we want to accept, then we would vote yes. So I think
But can't you have an emotion, couldn't somebody make a motion to accept the amendments?
Not
So
yet.
is it that we're only having discussion tonight, there's not going to be another meeting? This is our only time to discuss?
We have a
Is that what
motion on the
you're
floor that has been seconded that would lead to a vote up or down whether or not to
Tonight.
accept this settlement tonight. Yes.
So
And there will be
whether
public
hearings-
comment, we will, everybody in this room that wants to speak will get a chance to speak. And that presumably will educate all of our decisions as to whether or not we vote on this. And Meryl, don't sit down, that's all I can say.
That's fine.
So,
What if you
I-
need additional information in order to make an educated decision out of this discussion?
well,
then we
we'll
wouldn't
have to
be,
decide
then
that.
we might not be able to vote yes on the, so the vote is a yes or no on this particular settlement. And so the discussion right now is, let's pick it apart and see whether this is an agreement that we can agree that we would vote yes on. So if there are outstanding questions that we can't answer, I would think it would be very hard to vote yes. I need to vote no.
Okay,
And any amendments that we were to agree upon tonight would be added to the doc. Yep, yes.
yeah, the mics don't work, so,
Any amendments that we were to make tonight would be included in a fresh draft. Is that right, Meryl?
Well, this is a proposal that if agreed to by the select board, we know that Chelsea would also agree to. So if there were proposed amendments, then we would need to go back to them to discuss whether they would consider accepting them. I can tell you that I've had lengthy discussions about each of the terms in this. I've pushed on all of the terms, and I have some sense of where their lines are. So in that respect, I think I can also give you probably a fairly accurate weather report about whether those amendments would be likely to be agreed to. And if they haven't been raised, then I may not be able to give you that weather report, but it would be, it would have to go back to discussion with them.
okay. Well, so, board, we had a long and grueling conversation about this on Monday night. I know you all had a chance to ask a lot of questions in executive session, but I guess before we go into public comment, I would like to just offer opportunities for the board to ask questions of Meryl or pose any other questions that were unanswered at the executive session, and then we'll move into a public comment mode. So, does anybody have anything that is on their mind? Okay. So, anybody else besides Jim? Okay, so we're gonna start with Jim then.
Meryl, when we talked the other night, and I said that I preferred the first option, but, and you've been a great attorney for us, and you said the risk in going with that option is that everything that they've conceded to on this goes out the window. We get nothing, and you guys get nothing. You want to elaborate on that?
Well, yeah, I think that one of the important points of a settlement proposal is that it's an offer. It's an offer to compromise. It can be withdrawn at any time. They may say, at any time until it's accepted. So if the town wants to agree to proceed and they want to either take the first option and go to an appeal, or they want to take the second option and proceed to the PUC hearing directly, then one risk of that is that the terms of the settlement agreement will no longer be available as terms that the town can specifically agree to now and rely on now. That doesn't mean that some of these things won't come about through the PUC process, but there's no, it eliminates the certainty of the terms that are set forth herein.
Okay, one of the things that I've heard over the years, and Libby will back me up on this, that there were threats made by the Malones to completely wipe out the apple orchard, isn't that right? I got a guarantee that it'll be preserved.
No.
We didn't have that before.
No, that's not quite right. And that's, excuse me, Meryl, would you address the apple orchard clause specifically, please?
Sure.
It's not preserved. It's deferred, right?
Well, there's not an agreement to preserve it forever. There's an agreement that it won't be developed during the life of the Chelsea and Apple Hill projects. So that's something that they've agreed to commit to. It's not going to be necessarily be maintained in its exact present condition, but they've agreed not to develop it into anything else.
May I say something here, please? Because this affects me directly.
Okay, I'm going to break the rules right away. Go ahead. Please, Libby.
My house faces the apple orchard, which I used to own. And to say that they have no obligation to maintain the current condition of the apple orchard means that it will go completely wild. Maybe they're not taking down the trees, but I can tell you that I maintained it for all the years that I had it, and it should be mowed. It's part of the Apple Hill Association. There are rules in the association that say that each parcel needs to be maintained. So to say, on the one hand, that they will let it go wild, yet in number 9, they're talking about their fairly elaborate mitigation plan. To me, and this would be to their financial benefit, it would be much more sensible and keep that 5.63 acres looking much better to do no mitigation, because none of the mitigation they talked about will grow tall enough to screen anything for years and years and years. So they could save a bundle of money by not mitigating it, but having it mowed, maintaining it in some way that it looks presentable. That would cost them probably 1/1000th of what the mitigation would do. And that would be very important to me, who face that orchard every day.
I would just, in response to that, I would note that this agreement would not in any way trump existing provisions that apply to Apple Hill Association properties. I'm not intimately familiar with what those provisions are, but this settlement agreement wouldn't have any impact on those. We can't wipe those out.
Well, they have been wiped out because they've owned it now and they haven't maintained it at all.
And I think that there, if to the extent that the Apple Hill Homeowners Association documents have any covenants related to that, I think that those would be enforceable by the Apple Hill Homeowners Association.
Can't you add that here? Language saying that what this final sentence here says, for the avoidance of doubt, obviously we're all trying to avoid all kinds of doubt and confusion. We don't want to have to pay a lawyer to sue them. You know how that goes. You haven't even been able to sue them.
Well, we've certainly done our best, Laura, with a lot of town funding. So I think respectfully, Laura, they've done a nice job. Well, is it time for?
Well, you know what? I would like to. I did let Libby speak. I'm gonna hold off, Joe. I'd like the board to finish going through this, and then I'd like to open it up to general questions. So we can come back to that. But Jim, did you get an answer to your satisfaction?
Yeah, but I'd like a clear response from Meryl about Libby's question. And you said that you would give us, Meryl?
Yes.
You said you would give us a weather forecast with respect to, this plea to have it properly maintained.
Yeah, I mean, I actually, that is one that I'm not sure how they would react to. I think that the probable response is that those are private interests that can be vindicated privately rather than by the town. And I think they would also respond that any provisions that apply to that particular parcel that are, that relate to that would remain enforceable to the extent that they are interpreted in the fashion that that folks are suggesting.
So it wouldn't hurt to ask, though.
It wouldn't necessarily hurt to ask, and yeah, that's one I'm not sure. I can tell you that they specifically included that, so it wasn't the result of, you know, a long, prolonged negotiation. So I have no doubt in my mind that there's a reason that they included it. But that's pretty much that's what I can tell you about that.
But they would save a fortune if they didn't have to mitigate. So couldn't that be an option to go back and say the homeowner that when the mitigation was being done, from my view, says, please save your money, don't mitigate, and just maintain the orchard. It would save them a fortune.
I guess I'm not really sure what you mean by don't mitigate.
In other words, they were putting all for these years, they've been saying, they want to put trees and shrubs and stuff in so that my view, since my house faces it, will be mitigated. I will not see the solar things, I will not see that. That was their offer. But I've said to them repeatedly that putting the mitigate, my house is on a knoll. So putting trees all the way down there, it would, and they will not maintain any of them. They made that clear. So in my mind, save your load of money. Don't put anything in because it was being put in for me, in consideration of me. I'm very happy for them to not spend 1 cent on the mitigating and just, would they, you know, in cooperation, would they just, you know, have the orchard mowed or maintained in some minor way?
I am personally uncomfortable going into land management, how they manage their land. I know you sold the land to them, right, originally?
No, I didn't.
Or somebody, a prior owner? Okay, so it was sold to them, they bought it outright. It's good that there's no driveway going through there anymore as a result of the new plan, which I think is, hopefully, people are happy about. But it feels to me like we could have differing opinions on, excuse me, Laura, excuse me. We could have differing opinions about whether or not it's better to have it grow up or not. Now, I've been to your house and I know the view is beautiful and it would be nice from your house not to have it grow up. But I could imagine that it might be nice for everybody who drives that road to have some of that grow up so that they weren't seeing houses on what looked a little bit like a ridgeline. It's just a juxtaposition to that opinion. So I do think that land management might be something that would need to be addressed through a homeowner agreement.
I think that's right, and the other thing is this provision doesn't have anything to do with the mitigation, this specific provision doesn't have anything to do with the mitigation offered for the view in front of your house, in front of the orchard. It really pertains only to whether or not they'll develop the orchard itself. So those are really, right now, as I see it, those are two separate issues. I'm not sure whether the question of the proposed mitigation of tree planting in front of your house is still something that's live in front of the Public Utility Commission, but these are, this provision pertains simply to the development of that and the maintenance of the orchard itself, not any new plantings.
Meryl, this is a very germane question. It's a slight change, but on number 9. Well, so I feel guilty about this, but we're here tonight because 3 years ago, I asked Tom to hold an emergency meeting because these projects were going down and there was no screening on these projects. There was no proposed screening for either of these projects. And it's been sort of long, very difficult task getting there. But for me, the issue has always been not solar or no solar, but it's been screening. It's been about how do we appropriately screen things. And so as I understand it, this number 9 is something that the state was influential in creating, is that right? So I think this is really important in terms of if it goes up and we find that there are additional screening needs, how does it play out that we get what we need?
Well, I think that one of the issues that you raise is that post-construction review will be with all parties, and essentially they'll agree to add additional plantings on the property to ensure the long-term screening if it's necessary and in accordance with the mitigation plan. So essentially, if the parties to this determination can point out later on, hey, your mitigation plan shows this, and this is the reality, that they'll agree to come back and discuss and add additional plantings in order to make sure that the mitigation plan is complied with.
Who are the parties that you're referring to?
The parties will be the parties to the PUC proceeding.
So it's the town and the developer.
And Apple Hill, we are party, our party.
My understanding is it's the parties to the PUC proceeding. I could get some clarification on just to make sure, but that's my reading of it.
Well, I think that's very vague, and we need clarification on that. And who's final approval? If we're back to disagreeing on what's appropriate, then who's final approval?
And anyway, if it only goes to what they are saying in accordance to their mitigation plan, some of us feel that the mitigation plan itself is insufficient.
And I think you've raised those concerns in front of the PUC, and you can continue to do that. So the mitigation plan that's currently proposed is the one that would be pertinent to this particular agreement.
I think we're speaking in circles again.
Would you talk through just a little bit more about the mitigation plan so that everyone is comfortable with the creation of the mitigation plan and then the decision making around it?
Well, the mitigation plan that was developed was developed in connection with Chelsea 2, was developed in response to, I would say, the determination in Chelsea 1 to fill in the gaps of what the concerns were with respect to Chelsea 1. There have also been some recommendations made by the Department of Public Service aesthetic expert in terms of what that mitigation plan would include, and Chelsea has been somewhat modifying the mitigation plan in response to certain recommendations that have been made over time. The mitigation plan is what has been filed with the PUC. Actually, don't have a copy of it in paper here. I can pull down a copy of what has been filed with the PUC, but I expect that most people in this room have been following that pretty extensively, and the filings that have been presented. So it would be a mitigation plan that would have to be continue to be vetted. Ultimately, the mitigation plan that has been vetted to date and has been presented to the PUC to date.
But wouldn't this be the final mitigation plan that the PUC approves?
This will be the mitigation plan that is currently at play.
So in other words,
but let me finish though. They have to, if there's a final mitigation plan that does come down from the PUC, of course they would also have to would also have to comply to that, comply with that mitigation plan. And realistically, if it turned out that they weren't complying with the mitigation plan that is finally approved by the PUC, there is a right to enforcement.
So I guess I have a question to the board. Have you guys investigated and thoroughly vetted this? Because this kind of has come up out of the blue that you're making this agreement now. You know, to the best of our knowledge, this project was dead, and now all of a sudden it's back on the board, and you're making an agreement to this. But this was a hot topic when this project was on the table many, many months ago. And this was a key thing in this project. So, no, we don't know fresh out of our mind what this screening is, because we haven't been looking at this, because we haven't had days and weeks to know that you were negotiating behind the scenes. So my question is, have you revisited this? And have you made this a priority as you're sitting here behind the scenes negotiating the fate of our neighborhood and the town views from many key areas and businesses? Or are you just slipping this negotiation in without that consideration?
Okay, so question to the board, but what I'd really like to do, and we will address that, but what I'd really like to do is make sure there are no more lingering questions from the board, and then that will be our first question from the audience, okay?
Don,
So,
can I make a suggestion, because you skipped over this? I think it's fine that the board would ask their questions first, but if we're going to go section by section, that on a particular section, the board would have their questions, and then the public would have their input, so you're not getting
okay.
back.
Yeah,
We skipped over number 7,
Yeah.
there's still more there.
Yeah.
Right.
Okay, well, it may be that the board is ready to turn this over. So let me get a sense of, are we ready to turn this over to a public comment situation? Okay.
Yes.
So, let's move into a public comment situation. I'd love to have you amplify that if you'd like. Why don't we start with you?
Can we,
Introductions
I
would be great.
think that was a great idea to go section by section.
Yeah, so
Okay, all right, okay.
Which you skipped over.
Well, can we go to, I mean,
Let's go to the beginning.
yeah, I mean, I think if we're gonna go section by section, let's start at 1 and go through it so that we can get a really good sense of all the outstanding questions and concerns.
Okay,
Okay.
that sounds fine. Yep, that sounds good. So, so we are going to start at the beginning. Unless anybody feels like we need to go through the whereas comments, which I really feel like we don't, let's start on page 2 again with the therefore comments. Are there any comments from the board on section number 1?
No, are we just, we're finished with our comments?
I think we're finished with our comments. Okay, so are there any comments that people would like to make on section number 1? Let's start with that. So,
Introducing yourself would be helpful too. 'Cause I
so
don't
please
know
come
you
up to the
all.
mic. Please introduce yourself.
Yeah.
Well, so Cat TV can film it. Yeah. Yeah.
Yeah.
Watching this on TV to know anything that you're saying.
So for the first hour, they haven't heard anything?
Okay. Okay. Thank you, Laura, for putting up with that.
I do have a question about item number 1, and that is that you are now going to agree that the town that the Chelsea project is consistent with the town plan in effect in 2014.
Yes.
So, despite the fact that you have put in all sorts of arguments at the PUC already, showing that it isn't consistent, and I, as an intervener on behalf of Apple Hill, still do believe that it is completely not consistent with the town plan. What's the impact of you now giving up that argument and say, it seems to me that you are now saying you don't believe in the town plan, because to allow this development to go in and not only just to allow it through a settlement, but to say explicitly that it is consistent with the town plan, since I believe that there are many reasons why it is absolutely not consistent with the town plan of 2010 or 2014. Why does that seems to me that you are giving up your rights as a town to defend your town plan, and what kind of precedent is that?
So
and why does this have to be in here?
Before any board members answer that, I would just like to get clear with Meryl about, in the hypothetical, if we were to answer to this question that we did not think it was, or that we had some doubts whether or not it was contrary to the 2014 date, would that be something that would be used against us? Should this board not comment on that at this point? That's my feeling.
Maybe just leave it out. Why does it have to say that?
Well, that is, I think that you're asking two different questions. I think that the reason that it has to be in is, I mean, it simply is one of the terms that has been proposed and insisted upon. And so the question is whether the town plan in effect at the time of the Chelsea 1 petition, whether the Chelsea project now, as it has been changed, is consistent with that town plan. And so the town would be agreeing that the Chelsea project is consistent with the town plan in effect at that time. That is the Chelsea 2 project, and it does not mean that the town is taking the position that it is consistent with the town plan that has been adopted since. So it doesn't have precedential value with respect to the new town plan, which, as we know, the PUC determined does not apply to this
Okay, so
proceeding.
board, why don't we stick to listening to your opinions on this and not offer our opinions on
Because,
this.
Laura, so hypothetically, if we decided not to vote no on the settlement agreement and to proceed, and we answer that question, then we weaken our position, because because what we would be doing is then going ahead and litigating or presenting our position that the new Chelsea project is, we would be stating our opinion about the new Chelsea project in reference to the 2014 town plan.
I'm
So
not
I
an
think we
attorney.
don't want to answer
Can I
that.
follow up my question to Merrill? Because
Sure.
not being attorney, I don't know. I understand they want this in here because that means that we are claiming that they are completely in the right and innocent, and we've been wrong all along to be defending the new town, the more current town plan. But what I wonder is whether that has to be in here at all. I mean, and what if you say that we are not going to say that that's true? They still get, it's still a settlement. They are still going to be getting everything they want. We in Apple Hill are basically getting nothing. You mentioned earlier that we get what we, I don't know, you said something, Don, about what we are getting something, but that's right. So I'm just saying that I don't understand why we can't just remove that sentence, Chelsea project is consistent with the town plan in effect. That's my simple suggestion.
And I appreciate that, and I had the same idea, I'll tell you, and I've pushed on that, and that is a term that, you know, if Chelsea's going to agree to this, that's a term that they've insisted on. I can give you the weather report on that one.
Well, isn't that a red flag?
Yeah, right. Why?
Manipulation.
It's more than rubbing it in. And this is Peter Lawrence, and I'm a resident in Bennington, and I'm close enough to that I think everybody can hear me. By having that in there, it is something that the town is saying, not only are we entering into an agreement, but we're agreeing with your position, and that gets used against all the other interveners.
Right.
If you take that out and just tell, then it's just silent on that, well, it's going to be up to the Public Utilities Commission. But I understand that the Malones proposed this, and this is what the Malones want. Not unusual that they would want the best thing for them.
Right.
If they really want an agreement and want to move forward, then just taking that clause out and the Chelsea project consistent with town plan in effect in 2014 doesn't take away what they ostensibly are getting from this, but it protects other people in the town.
I understand that, and I also understand that that the reasons why they'd like that in there, and I guess what I'm presenting to you today is the agreement in the form that after all of the debate and all of the pushing that they were, you know, we had some concessions from them and some things they wouldn't concede on, and that's one of them.
So the town is selling us out.
Well, I would,
And all the other interveners.
Can I yeah, can I add something here? As the intervener, as the pro se intervener, Maru and I, Maru from the Country Club and I are the last standing warriors here, apparently, and we are still planning to go to the technical hearing on the 20th, which now, if you vote on this, you won't need to do. So it's going to be up to us to try to be the last defenders of our town plan.
Our old town plan.
Our old town plan.
Yes, And the old town plan is very good at defining industrial zones, rural conservation zones, beautiful views. We have a very good 2010 town plan that you all should be very proud of, even though it's been improved upon. So it's going to be up to us to try to defend the town plan, even though Maru and I don't have standing on that. We have to do it indirectly because we only have standing on aesthetics and wind and noise and pollution. But the aesthetics are a big thing, and we are arguing about the aesthetic views from the country club, from the Southern Vermont orchards, from the Welcome Center, from SBC, from the college, which is on the National Historic Register. We have photos to show that these are very important sites that will be ruined to a great extent by having black boxes on the hillside, which you must remember that the mitigation plan that they are providing to us is not just trees. That sounds very nice. It's black plastic sheathing around 2 projects, which is for a total of 18 acres or something like that. And what is that going to look like on the hillside from all of these distant views? So you may have reasons as the town to not keep this fight up, but you're selling us out by including this in here, because we will lose that kind of argument, and we are still interveners.
So point well taken. Thank you for making that point. And so all of these things we'll have to take into account if we take a vote. So when we take a vote. So any other comments on number 1? Okay, number 2. This is about the payment amount. I don't know if we want to be specific about this, but I would say I think it's probably worth just saying that the legal costs, if you don't mind me saying, are up to $105,000 on this project already, the direct legal fees.
Well, let's clarify though that that's not just this project.
Okay, yeah. And the town, let's not clarify that too much. And then the town staff also has a lot in it, and we came up with a number that was somewhat higher than this. And this represents about a 3/4 recapture of the town cost. 100% of the legal out-of-pocket and about 3/4 of the town cost, which was $139,000 and change, as I recall.
I think after vetting it was in the 120 range.
127,638. Yep. So a little more than 75% recapture on the staff costs there. So are there comments to be made about that?
Yes.
Okay, please, Joe.
Joe Schoenig, Apple Hill. You should have taken the $200,000 initially, but for some reason, you guys didn't. You women, people, all of you. And it's because, I hope, that you had a sense of doing the right thing and not appearing like a prostitute or a bunch of prostitutes. Well, guess what? You're right back there, and worse. Thank you.
So we'll see how much this devolves into name calling tonight, but hopefully not too much more than that. Number 3 is the developer and its affiliates. Marilee, I thought your explanation of this was good. Are there particular questions from the audience on this for our legal counsel? Okay. Number 4, this is the 10-day issuance of final order. This is for
withdrawal of claims.
Withdrawal, and I can't recite without it in front of me the different counts. I don't know if that's necessary, but we did review that.
And the withdrawal of claim for damages.
Meryl, maybe you could flesh this out a little bit, because this says there is something that's in the Vermont Supreme. Could you explain what's in front of the Vermont Supreme Court and what the other things are?
Yes, I'm happy to do that. So the other side of this legal coin has been some civil litigation outside of the PUC's jurisdiction. Just to give some really quick background on that, it was initially filed in the Civil Division, Chittenden County. The town of Bennington, because there were a number of federal claims, removed that case to federal court in hopes that it would be quickly disposed of, and it was. It was immediately dismissed by the Malones in favor of filing a suit in the Environmental Division. The town filed a motion to dismiss. That was granted, so the town won, and the Malones have now appealed that decision to the Vermont Supreme Court. And the sole issue before the Vermont Supreme Court is, well, technically there are two issues. Number one is the appeal on the basis of which court would have jurisdiction of the claims that were raised. Would it be the Civil Division or the Environmental Court? The other issue was the town's cross appeal for its fees, which it had requested and which had been denied. The other thing I'll point out about this is that litigation, pretty much no matter how the Supreme Court rules on that, it's probably going to go to another court. So that's just going to be because the only issue they're deciding is which court has jurisdiction. So the obvious aftermath of that decision will be that they'll go to the court that has jurisdiction over those claims. So
for that case, it's just in the Supreme Court. Has that been briefed by everybody?
It has not been briefed by everybody. Sorry, go ahead.
Okay, so does this contemplate that will still happen? That it'll be briefed, argued, and there'll be a decision regardless of this agreement?
Yes. However, if the aesthetics expert decides that the preferred sites or the two new projects are within a preferred site, then as one of the many conditions to that decision or conditions subsequent, I would say, to that particular decision would be that it would be withdrawn and the litigation would end.
So my other question is, and this may not be something that can be answered in open session, I understand that, and it can't, but it seems that one of the things here in 4 is the developer is dismissing claims for damages against the town. Merrill, did you feel there was any merit to their claims for damages?
Careful.
I'm not. I'm gonna just not answer that question tonight, and I apologize. I'd like to, but it is pending litigation.
Number 5, parties agree in good faith to extend applicable filing deadlines. Number 6, 10 days of the effective date of this agreement, the town agrees to withdraw its cross appeal in the lawsuit.
Now, is that redundant to 4?
No, because that provision, that's a cross appeal pending before the Vermont Supreme Court, so that's the case that's staying live.
But you have to withdraw the cross appeal.
Withdraw our cross appeal, yes.
So they get to proceed with their appeal. The town has to drop its cross appeal.
Yeah, the reasoning behind that is because if we even get that far, the cross appeal is solely on the issue of fees, legal fees. So if those are being reimbursed, then it's a redundant cross appeal.
Okay, now we're at number 7, the apple orchard. So, thank you.
Good evening. I'm Bill Knight. I'm president of the Apple Hill Homeowners Association. Under this number 7, it says they have no obligation to maintain the orchard. Well, when they bought that land, they became a member of our association. And we do have bylaws that we all have to stick to. We have meetings. They expect, as part of, they say they are members of the association, they expect to get emails notifying them of meetings, anything that goes on. So therefore, they say they are a part of the association, so they should have to, it should be in there that they have to go along with all of our bylaws, and part of those is to maintain the land. I mean, if they say they're just going to let it go wild, it's going to be growing across Libby's driveway, there's going to be weeds, there's going to be bugs, there's going to be everything else. So I feel like there should be something that they have to go along with everything we have in our bylaws, and they shouldn't be able to make their laws or jump in and decide what they're going to do.
Well, I think Merrill answered the question by saying that this does not trump pre-existing legal agreements. Have I got that right?
Yeah, the bylaws still stand.
Those are legal obligations, those are bylaws, and that's kind of my question. Are they going to be able just to come in and decide what they're going to do?
They're going to be able to do what they're allowed to do under the bylaws, and they're going to be restricted to the covenants in the bylaws.
Well, I think it's simple to state in accordance with bylaws.
Yeah, it doesn't actually.
That's really not for the, I'm sorry, but that's really not for the town to do. The town doesn't have any ability to enforce a private agreement among private landowners in that capacity. I mean, that's.
But it looks like you're trumping them, even though you're saying, you could even say these do not trump any other private agreements. I'm sure you could figure out some kind of legal language to keep it proper, and also say this does not trump any ongoing whatever obligations.
Why is that necessary, though? Isn't that an obvious legal principle?
Well, you know,
nothing is obvious with these folks. They will take every advantage, as we know.
What's the purpose of having that sentence in there anyway? Why is it important?
Well, I don't know which sentence.
Let me just go back to the initial point, which is the town cannot waive your bylaws. I mean, by virtue of this agreement, the town doesn't have the ability to waive the obligations under a separate set of legal agreements among other people.
Well, why is it important to have for when it's about the PLH shall not have any obligation to maintain the current condition? Why is that important for them to have in this settlement agreement if it's not something they wish to avoid?
I probably so that to make it clear that the town can't come in and try to make them do anything on that land.
Well, there is, Ms. Harris does do some mowing there, and there is a pattern of mowing there, and it may be that they don't want the obligation to have to mow that property.
But they have to in accordance to the bylaws.
So then that would be something that they would have to take up.
That with that statement. So take it out or tell them they have to adhere to the bylaws.
Yeah, it's kind of nebulous.
I don't think it can trump the bylaws, though. Can it?
Take that sentence out.
Yeah,
They're not complying with it. They've never complied with it.
Well,
what's the purpose of it?
so my sense of this number 7 was that it was something that I pushed hard to get, in that I really wanted to know that apple orchard would not be developed either into solar or into anything else for the sake of
You can't
the.
do that by
So
the property rights. It's a residential lot. It is a residential deed.
Yeah.
Paul Boney created that as a residential lot, and as a member of Apple Hill Association, they can only have residential uses. So to give them, this sounds like you're giving them added protections for not caring about what that looks like. Take it out.
That's your suggestion.
No, can I ask a question?
Oh, yeah, sure. Yeah.
If we were to take your suggestions to remove number 7.
Yeah.
Okay, so we're just, if we're hearing it out, we're accepting it.
Hang on just a second.
Like, what's the idea here? Let's continue to move through all these. I mean, we're hearing you, absorbing it, and so.
I want to get a quieter voice in here. Chad, you've got some points you want to make
I
here.
don't ask a lot of questions. If we were to remove 7 altogether, what's stopping them from clear cutting the lot?
Then what would stop them from clear cutting the lot would be the Apple Hill Homeowners Association enforcement of their own covenants. So,
But it's a residential lot though, right? They could not. They could. So by having 7 in there, it keeps the
It doesn't say that. It doesn't say that they can't clear cut it.
Can I speak, Merrill?
Yeah.
Don, can I be recognized on this?
So, just a minute. Yes, as soon as we get Merrill's, Merrill, if you have other points to make on this.
Bottom sentence.
then now would be an opportunity, but then I'd like to recognize Peter on this question.
I'm happy to go
Okay,
ahead.
go ahead.
I think this might help. I disagree with the other people from Apple Hill about getting rid of it because, quite frankly, I think there's protection. My problem is with the way this clause is written, is that it's vague and the two senses are contradictory to each other. Where it says that they agree not to develop it into any other use other than its existing use for the life of Apple Hill and Chelsea, okay, that suggests to me that it stays the way it is. And whether they mow it or not, that's a separate issue. The next sentence, though, for the avoidance of doubt, neither PLH nor the developer shall have any obligation to maintain the current condition of the apple orchard, seems to contradict keeping its existing use. Because that would suggest, well, they could go down and they could clear cut it. They could just, turn it up, which is one of the things that at one time they did ask to do, they did threaten to do, is to clear cut it, to level it. So my problem with number 7 is that it's vague and contradictory, and lawyers well know that where there's anything that's vague or contradictory, that's fertile ground for litigation, and we want to try to avoid that. So I recognize that the developer may not like the town coming back saying, here are some adjustments that we want to this agreement, but I think you have to do that. And that's the paragraph 1, paragraph 7, to clarify that, to more definition, more specificity in there. Those are things there. And then the mitigation plan in 9, there was a lot of discussion about that. Well, what happens if there's disagreement about additional plantings? There needs to be some clarification of that, otherwise you're just buying into more litigation.
Okay.
And then we'll get to 10, which is more.
Yes.
So let's wait till
Peter, you're breaking your own rule.
Yeah, let's go in sequence.
I know.
So good point. I mean, I guess the one question I would ask you on 7 is, if you had to choose, would you rather have it in or out? As is, in or out?
Oh, as is?
As is, in or out?
Oh, as is, I would want it out because this is going to be litigation. But a clause like this should be in here. And I don't think you should agree to something that doesn't have some protection for what's going to happen with that property. And again, going back to what I said before about paragraph 1, if they are balking about fine-tuning that, that's a huge red flag. It's a red flag for us. We're citizens of the town. It should be a huge red flag for all of you about that.
Okay. Do you have any comments on number 8 while you're at the mic?
Nope.
Okay. Other comments on number 8? So this has to do with.
I had a comment on 7 still.
Okay.
Same person, Joe Schoenig, Apple Hill. I'll be good this time. I have been mowing the orchard for the past 3 years. I've been mowing it, paying for the gas myself, my labor, doing it to make it look nice. When I went in and took pictures of the Apple Hill and Chelsea, the next day after those pictures were turned in Montpelier, they came out and put signs up saying absolutely no trespassing. They not only did that, but they have approached me on several occasions saying, why did you do this? And I told them, it looks terrible and I'm not doing anything but upgrading the quality of their land. And I think that gives somewhat, again, an indication of the people. They're not to be trusted. They really aren't. They're vindictive, terrible people, and they don't give a darn about this area.
So I don't want to go too far down that rabbit hole, Joe. Thank you for that comment. But at some basic level, you were mowing somebody else's property without their permission.
Absolutely.
So I mean, at some level, it's a form of trespass.
Yeah, except your signs were
at any rate.
If somebody came and mowed my property, I would be furious. So if somebody came and mowed my property without my permission, yeah, so. Not my lawn, actually, if anyone wants to mow my lawn. Yeah.
Didn't even know what was going on.
Yeah.
I have a comment.
Okay, on 7?
On
Yeah.
7,
Okay.
yes. I just would reiterate what Peter said on number 7 and in general, that the town was offered a substantial amount of money several months ago. And that doesn't differ that much from what this offer is. And the thing to remember is that our duty is not to be pushed around, not to be bullied, not to be told that this is going to disappear if you don't do this right now. It doesn't have to be right now. They've come to the table before, they're coming again. They're going to make money from this. They want this money. We have more power than we know. Let's not give up now.
So just to be clear on the money, yeah, oh, sorry.
Diana Lisa, sorry.
Just to be clear on the money, there was a $200,000 offer that was quite a while back that we were asked to consider. That was prior to a lot of water under the dam, or a lot of water under the bridge in terms of legal costs and staff costs. So while if we had taken the $200,000 back then, it would have been a bonus. At this point, taking the $202,000 and change doesn't even recapture all of our costs that we put into fighting this.
And Meryl, can you please remind us of PUC's ruling in recent that's kind of got us to this point, as far as relating to which town plan and what we're considering?
No, we got it, that it's 2014 town plan.
Right, okay.
But it's the cost of doing business.
And so we now are faced with...
In your opinion, it's the cost of doing business. We represent the entire community, so it is the cost of doing business, I agree with you. But we are tasked as a select board, and I will speak personally, to oversee what would be the impact of the entire community and how that budget speaks to everyone, not just a few.
But it's a budget, it's our town for a lifetime, not just for this fiscal year.
I don't know how you want me to interpret that, but okay.
It doesn't, this situation doesn't have to do with just this fiscal year or next fiscal year. It has to do with the town for our lifetime.
Oh, okay.
To follow up on Carson's question, Meryl, maybe you could clarify the decision to use the town plan in effect in 2014. Was that made by the hearing officer or by the whole Public Utilities Commission?
That was initially made by the hearing officer upon the request of Chelsea. They initiated that request. The hearing officer decided that Chelsea was entitled to enjoy the benefits of the earlier version of the town plan. The town appealed to the full PUC, and the full PUC agreed with the hearing officer. So that, we've really tried to exhaust the options on that one that are immediately available to us.
That happened August 30th.
Yeah, that was
happened
just
August 30th, and we thought we were going to prevail. We were almost certain we were going to prevail on that because it seems to me the PUC made the wrong decision on that. And I can't speak for the board, but I can speak for myself when I say I think the PUC really missed it. I think that the hearing officer missed it. I think the board missed it. It just shows there's no public in PUC. It's Utilities Commission, and I get it. I get that frustration, but what we're tasked with now is what's our legal position? Right. What is our legal position given that we lost that really critical point?
Right. And the only follow-up with that would be an appeal to the Supreme Court, right? With all that entails.
Right. So then we take it to play that out, take it to the Supreme Court, win or lose, we come back and we keep fighting with them. Okay. So.
Yeah, that's the clarification that I was looking for.
Right.
Well, and just to add to that point a little bit, you'll notice in that August 30th decision from the PUC, it's full of policy. I mean, it's bad public policy not to allow them to do this. So it really focused more on policy than law, and I think that there's something to that.
Carson, may I say something else?
I would address it to the whole board, not just me, Libby, but okay.
It was in response to what you had said.
Sure.
And,
do you want to come to the microphone so we make sure we get it?
Thank you. I wasn't going to make her do it. I appreciate that you did that.
Well, there's only 20 people in this room and hopefully a lot more are watching.
I think I forgot what I was going to say now.
That wasn't my intention.
Yeah. Oh, I know what I was going to say. So, I understand the feeling that the Apple Hill neighborhood and the Apple Hill neighborhood and the Apple Hill neighborhood is only one neighborhood in the town of Bennington. That's totally true. But if you discount the Apple Hill neighborhood, if you look at the two rural conservation, these two projects in the rural conservation zone, and what's going to happen to the town's views, to the tourists to the town, that's really, really important. It's so much more important than the Apple Hill community. It dictates what the town will allow to happen to those beautiful, unimpinged aesthetic views into a hillside gateway into Bennington, into Vermont. And I think that's really important, far more important than our little neighborhood.
And just I would remind you, Carson, not to respond in a way that is expresses a strong opinion on the town plan compliance. And we can disagree on a lot of things, but you just need to be careful about that, please.
Thank you for your comments.
Excuse me, your name, please?
Libby Harris.
I think we do have to be careful as a board to not to stick with the facts and to stick with what we know. It is, it really is my opinion that these are different projects, but that perhaps is, I may be influenced by you on this one a little bit. It feels to me that they are, the PUC missed it.
Hi, my name is Maru Leon, and I'm I have party status here, and I'm also, very upset about this project, and I'm especially upset about it because I have felt from the beginning that this took into consideration only the views from Apple Hill. Like, nobody has paid attention during this whole project from 2014 until now that the entire valley's views were going to be affected. And it, to me, is shocking. Vermont and Bennington depends on #1 industry is tourism. And this is going to be affected. The views, the pictures from, looking at the hill going up north, you're going to see these big black boxes from the monument, from SVC, from the country club, from so many places. And how does the board not take into consideration when this is happening, when this is being proposed? We are all for renewable energy. We are all want to do that for ourselves, for the environment, but not at the expense of everybody else. When Carson agrees that you're taking care of the entire community by minding the budget, by minding how much is spent on this project, but we have to mind what's going to happen after, the repercussions of what's going to happen. If we continue to erode the visual beauty of Vermont, people come to Vermont to get away from the industrial zones that they live in, New York, Connecticut, New Jersey, and everywhere else. But they come to Vermont to escape that. But if we start opening up the gateways to start putting solar power everywhere we see, which is what's happening right now in Bennington, we're going to all lose because businesses will continue to go, hotels will continue to be depleted, not enough. It's not good. It's not a good plan. It's not a good vision. It's like we're taking care of this now, but not thinking about the future. There's a reason why billboards were banned in Vermont. There's a reason why, we have to look at this long term. Solar power might not be that efficient in 10 years, and yet we're going to be stuck with that hill for the rest of our lives. It will be clear, the forest will be gone, but the views will be damaged forever from SVC, from the country club, from Bank Street, from Monument Avenue, from the monument. That will not be solved. Thank you.
Thank you for your comment. I will try not to, bristle a little bit, but I will say that we have been thinking so much about this. I, in particular, have been thinking so much about this for the past 3 years that I can hardly stand it. But the emergency meeting, again, that was called 3 or 4 days before the final approval for these projects was meant to go through, was called because there was zero screening. There was no screening between the road and the project. And if you've probably all seen this ad nauseum, but the Chelsea went right out to the road. There was no screening at all. And as a longtime planning commission member and a kind of a land geek wonk thing, I just couldn't abide by the idea that they wanted to plan the screening after they got the permit, which is what they had proposed. And so we threw the brakes on it, and that started this protract, this long 3-year legal process that we've been through. And during that process, if this goes through, there have been some marginal gains. They're small, but Apple Hill has been reduced in size 26%, I think. Chelsea has been reduced in size something like 40%. So there's I think the number is something like a 35% overall reduction in size as a result of going through this legal process we've gone through. In addition, there was zero screening, and now in some locations, for example, the south side of Apple Hill, there's a couple hundred, 200 or 300 feet of natural screening now, and there's somewhere between 100 and 200 feet of screening around most of Chelsea now. So it may not be as much as we wanted, and I'm sure it's not as much as you wanted, but we have been fighting hard to get there. We've been fighting hard to get screening and to get this thing into a situation where we felt like it was not going to be an undue impact on the community. So we can disagree about what the outcome should be, but please know that we've been working really hard on this, and we've spent a tremendous amount. It's been practically a full-time job for our legal counsel to fight this.
I get that you guys have been working hard on that, and I appreciate it and the thought that's gone into it, but I just have to ask. Okay, driving on the highway, you might have gotten a little more screening. When you're at the Welcome Center, when you're at the Country Club, when you're at the Monument, is that screening going to help? Answer that question.
No, so
that little bit of screening that you're talking about with a little fence and a little bit of brush. When you're at the Country Club and you're up high, when you're at the Monument and you're up high, when you're at the Welcome Center and you're up high, you honestly think that screening is going to help at all?
Absolutely not. No. And I think that distance could be a mitigating factor for that. If you're a mile and a half away or 2 miles. So we have to agree to disagree on that, because that's an aesthetic judgment.
And that's what you're going to cover businesses that are going to be impacted by that.
It's also not the screening alone, it also is the reduced project size. That's a mitigating factor.
I mean, I will say, I think a lot of us spend a lot of time driving around looking at what is this going to look like? What can we imagine this is going to look like from different places? It's absolutely true. If you're looking from above, there's no screening that we can do other than distance.
So why was that never taken into consideration?
It was, Maru, it was part of the, this has been, looking at what this was going to look like from around the community, and there were people on 7A that have come and talked about their concerns about what it would look like from, in their view. There is no, it has been a consideration, and it happens to be that the Apple Hill community has been the most vocal and has been the most steadfast in really following all of the proceedings that have happened. But certainly they are not the only people who have had input, and they are not the only people and that is not the only lens through which this has been looked at.
And everything we've been doing up until this point has been to try to stop this. Everything we've been trying to do up until this point has been to try to stop this until August 30th.
I'd also point out that in all likelihood, you'll see the views from other locations in the town's filings referred to as long-range views. So that does appear in town filings along the way, consideration of long-range views.
Okay, I feel the need to move this along. We really technically only have the space for 2 hours, but let's talk about number 8, which is the first of the Battle Creek projects. This is about a 10-foot setback.
For the
It
Carbone.
feels to me like the select board had no problem with this when we discussed it. Are there problems? Would people in the audience feel differently?
Can you just explain what side of that it's on? What's the western side?
Carbone.
Sorry?
Carbone.
Okay.
So this is Battle Creek 1, which is all in the industrial zone, so preferred site, yeah.
And it's really going to be the setback along the property boundary with Carbone.
It feels like not something we should spend a lot of time on to me. We're back to number 9, been here before already, but deja vu all over again. So this is back to the mitigation plan. Are there further thoughts that, Peter, I might offer you the opportunity to go first if you have further thoughts on number 9.
As Wendy said, it's important to have language in there. What happens if all the parties don't agree on what additional plantings would be required? Or some way of determining what additional plantings would be required, because otherwise this provision is really sort of meaningless, because it allows the developer to say, well, we think we've done enough. And we've done our studies, here it is, it complies with the letter of the Public Utilities Commission, CPG, and nothing more is needed, and they get to say that under this, even if everybody else feels, wait a minute, this isn't enough, that more needs to be there. So again, and I think I recognize that for the developer, giving other people some power and a say, the town residents, is something they want to avoid. But I would hope that for the town, you would say, if we're going to sign a settlement agreement, you have to give us something that makes this meaningful. And Meryl, I know you've been working on this for a long time. I have a lot of respect for you also. And I think you could probably come up with some language that would give some protections to the community in that. And I would not agree to this the way it's written. And I would urge the board to say, well, we're not going to agree to it, we're going to make a counter proposal, even though those negotiations could be very, very difficult.
Can I ask?
Yeah, come up to the mic, please.
No matter how many times I think about these projects, I cannot get out of my mind that what we are going to end up with is acres and acres of black boxes on these hillsides. It's not going to be solar panels. We've gotten used to seeing solar panels screened or unscreened. And often if they're unscreened, they're very ugly. If they're screened, they're tolerable. But their mitigation plan includes that black screening. And Meryl and I had a discussion about this. I've seen, I don't know if you've all seen the samples that they sent around. They call one green. It's very hard for a lot of people, including me, to determine whether it's green or black, because to me it looks just as black as the black sample. In any case, that's what we should be thinking about, what we are going to be seeing. We're not going to be seeing a solar panel project, 2 solar projects side by side with trees around it. We're going to be seeing from a lot of views black plastic boxes. So what I'm following up on what you and I were talking about, Meryl, before the meeting started, which is, what if if everybody in the town and the parties live with black boxes for a while and decide that is more than we can tolerate? Is that going to be something that would be open to future adjustment on the mitigation plan, or are we only talking about trees? Are we talking about saying black is intolerable, we want beige? We haven't seen anything when we asked for samples, which we were as interveners, we were asking for samples for about a year, I think. They finally showed those to us a few months ago, and they pretty much look black, even the green ones. So that's that's my question here about this mitigation plan. I think we should have language in there that includes the aesthetic judgment about whether the trees or the black plastic is what we want. Is it working? Maybe they're right. I can't imagine that they are, but I'll give them that. Maybe it does camouflage. I can't imagine how it will camouflage in the winter when everything is white and we have black plastic boxes on those hillsides. What will that look like from the country club or from the Welcome Center or from the monument or a lot of other places? So that's my question. And that's a suggestion for another adjustment in the language.
And actually, just to be clear, just generally, but also with respect to that comment, I will say that a lot of the issues that aren't specifically dealt with in this agreement or aren't spelled out in here are still things that can certainly be raised and requested in front of the PUC as
yes, but that means
well, let me finish.
Yeah.
Those are things that can be requested in front of the PUC if those are your concerns. They can also be addressed in discussions directly with the developers, I think, if they would that's part of the process is talking to each other. But I'm just pointing out that this agreement doesn't foreclose those same arguments from being presented to the PUC by other parties.
Can I answer that?
No, it wasn't a question, but...
Well, can I comment on that? What we have all learned, Libby and Maru and I have learned as citizen interveners at the PUC, is that they're very respectful and we have a right to be there. They've limited what we can ask about. They've limited what we have standing on. And they really pretty much ignore us. So to say that we should somehow, suggest this at the PUC, we certainly can. But that doesn't mean we have any impact whatsoever. We have pretty much been ignored. So we feel we're doing our best, but without the town and without the Department of Public Service, who have legal counsel, we are not experts on anything. For us to say we want a better aesthetic plan, the only way they would take us seriously is if we had an aesthetics expert. As citizens, we can't pay for aesthetic experts. We can't pay for legal counsel. We are the legal counsel. And we're doing our best, but I would respectfully say that I would rather rely on you putting this into this agreement so it's in writing and they sign it to have some future judgment about the black plastic. Because we may all, including the town, including maybe you folks, who even though you are all in agreement that it's smaller so it's okay, think about black plastic on the hillside.
Can you not preferably put thoughts in, how we kind of concur, and you kind of said like you're assuming you know what we're thinking, so if you want to
well, I'm looking at Don because he's sort of, I assumed, speaking for the board.
Thank you.
No, yes, thank you for saying that, and no, I'm not speaking for the board.
Okay, I will not make generalizations. I don't know what you're thinking. All I know is that what I was saying. So if I insulted you, I'm sorry.
Yeah, I'd love to not have this be something, maybe it has to be, but I'd love to have this not be something where we have to sort of debate how bad black plastic is going to look from the monument or something like that.
I wasn't debating it. I was asking you all to picture it, and I was simply trying to put the context around my request, right, that the language be extended in that section, whatever number it is, to make sure that that's part of the mitigation plan in case we decide, or whoever it's going to be who will have future power over these discussions, that we either like or don't like how the black plastic works.
I do feel your pain on the PUC thing, Laura, but I think our attorney was just saying that the possibility is not foreclosed. I don't think you were suggesting that as the most practical route, but you were clarifying that was
as a general proposition for these provisions.
okay. Number 10. This has to do with Stark and Warner and preferred sites. As you hopefully all know, the preferred site language is really what's at stake here. If something is fully screened by natural vegetation, right, Rick? We wrote this. It's considered a preferred site, and so what it sounds like you have negotiated is that there would be a third party that we would get to recommend, and they would recommend 3 and they would pick 1. And the weakness in this, if I may say, is that if the preferred site, if it's deemed that it's not a preferred site, they can still challenge us, right?
If it's deemed that it's not yes, that is the weakness, is that they can continue to move forward and propose the project and challenge that determination in front of the PUC.
Yes.
So
what's
to be gained is a specific assessment by a third party to render that determination in the first instance. And if the determination is that it is within a preferred site, then it's kind of a watershed of other things that tie this proceeding up.
I don't understand that. Don't we have a map that says preferred and unpreferred?
There is a map that shows preferred sites and unpreferred sites. That what we used to call Battle Creek 2 and 3, which are now Stark and Warner. They're calling them Stark and Warner now, uphill.
Define what Stark and Warner are.
So Battle Creek 1 is the proposed solar installation that's in the industrial zone down by Carbone. And Battle Creek, what we used to call 2 and 3, were the ones that the town were not fond of, and they were outside of the industrial zone and therefore not a preferred site. Right, Mary? So we, but within our solar siting, which was in the 2016 town plan, we did say that something that was completely screened by natural vegetation could be a preferred site.
There are other criteria as well that you could get it under. Yeah.
So we changed our town plan, but it was pretty definitive to make it green.
No, we had a
That was part of the amendment to the town plan that not only adopted the map, but also defined what a preferred site is.
Yeah.
I just want to clarify, we had a very definitive town map, and now we made it a gray area.
No, it was all part of the same.
It was all at the same time.
No, it was all part of the same process. So what we did was we went through. I mean, Rick, would you like to talk about how we did this?
But my question is
I'm sorry. Would you? Yeah, I know it's hideous. But thank you very much for doing it.
And let apply across all fronts too.
What's that?
Make the comments.
Yes. If you give your name too, please, Rick.
My name is Rick Carroll, and as most of you know, I've been here since the beginning. And I understand that about Battle Creek 2. That's right directly behind the public house, correct?
2 and 3 are up on that hillside, yes. Mm-hmm.
Okay, so what they're asking to do is for us to overturn that, and I'll have to look back as far as any site that anybody picks out, from it sounds like what you're saying is, it can become a preferred site as long as it's screened all the way around.
That's how we wrote it.
That's crazy.
Apple and Chelsea are non-preferred sites.
Yeah, that's how we wrote it. And you may remember that was because we felt that there could be certain places around town that weren't in the industrial zone, that were completely screened and therefore there would be no reason why you couldn't put solar in there. But we put a very high bar on it. It had to be completely screened by natural vegetation, so they can't be planting things to get the screening they need.
So for a complete nightmare.
I'd really like to look at that again, because I'm really kind of surprised that I thought we were going to come here and talk about Chelsea and Apple Hill, and obviously we're not. So, you know, one of the things that I wish that the board had done is, you talk about screening, you talk about you've all driven around and looked at it. I've just spent 4 days looking at rebuttal testimony as far as the aesthetics go of it, to go back upstate and testify. And nobody from this board has ever called me and said, listen, Rick, let's get in your truck, you show me. You show me exactly what you're talking about. If anybody had done that, and I wish you would now, I'll take it to places it's going to be seen. I'll take it. I've taken 2x6s and put footmarks on them and stood them out there. If I take you people out there now, I guarantee you that not a lot of you will know where it's going to go. I'll show you. So I wish you'd have done that. And you still have time. Our town plan is a good plan. And don't let it down now. It really doesn't deserve it. I mean, we can go forward with this, with fighting this development. It's going to affect Bennington for a long time, and you're going to see it from a lot of different places. Give me a call. I'll check on that. I don't like...
I'm telling you, we wrote it together with Mary.
I'll understand, I understand, but I'll take a look at it. But I question number 10 altogether right now, because Malone's have come in and they really are just sweeping everything. Give it the town plan a chance.
Yeah, the way our current town plan reads with the amendments is that if you have a preferred site, and there's a route to a preferred site, and we wrote it.
Well, I'm not saying we didn't, but I'll take a look at it.
Yeah.
You know, I mean, I really want to look at it, and right now, it seems like this decision is going to be made tonight, and we have so much to review. It's overwhelming for what we have to go through right now.
So Peter and then Laura. And then Joe.
Well, these are comments and questions on 10 and 11 flows into that. As I said before, I had some concern, or I don't understand why this is silent about what happens if Stark and Warner are not preferred sites.
Because we tried very, 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 very hard to get something in there. Maryland.
Well, I understand. And again, this goes back to at what point you dig in your heels.
Well,
let me finish, Stuart, because there was a lot of talk about the whole town. Well, this affects the whole town. The public house put a lot of money into its renovations because of its view. Howard Hill Motel advertised itself as home of the, $1 million view. These are other businesses that exist, and people who live in the Bennington area who are going to be dramatically affected by this. And I think this should not be agreed to. And if the Malones say we're not going to do it, if this is, the line that neither side can cross, that happens. But I don't see any way the town can agree to an agreement that is silent about what happens if these are not preferred sites. You said it's a very high bar. Great, and I hope that's accurate and that's true. But if it's a very high bar and they can ignore it, that's meaningless.
Well, that's why we wanted independent third party. But
but then that gets to number 11, and these go together. Number 11 is also something, the way it's written, completely favorable to the developer and completely oppressive to everybody else. Because this says not only they retain all rights to it, but they have the only discretion as whether this can be used as evidence. So if that independent consultant says these are not preferred sites, the developer gets to say, you can't talk about that. Your agreement prevents you from raising that. That is, in my opinion, completely unacceptable, and is a reason for you close the books and say, okay, we'll see you in court. You know, that is something that's not acceptable. And there needs to be language that says, once this final report comes out, I mean, it binds the town if it says these are preferred sites. And there's a lot of detail about binding the town. There's nothing that binds them if these are not preferred sites.
We understand the point. Thank you.
Yeah. Well, and Don, this last part about the work for hire and sole discretion or not to file the final report, you got to change that. You got to get rid of that. And again, I've said this before, that's a huge red flag. If that is still in there, they get to dictate to the town. And even if the town has favorable evidence, the town can't use that. You've got to say, no, we're not going to agree to that.
So before we take other comments on that, I'm going to ask Meryl to directly reply to those two. We had a lot of conversation about this, and I know there's been a tremendous amount of work and negotiation done on these points. So why don't you give us the full Monty on this?
Okay. Yeah, if the projects are determined to be located on a preferred site, then you're correct that that does bind the town to say, okay, well, they're on a preferred site. That's what the siting amendment is for. If they are determined not to be on a preferred site, you're also correct that the town, it's silent because you're back at, I mean, you're essentially back at square one, and they can make their arguments, whatever they may be, and the town can make its arguments, whatever they may be. The town's not entitled to use that particular expert's report. That doesn't preclude it from using a different expert. The town won't have paid for this expert. They won't have paid the bill. So, in essence, it gives a path forward if it's a yes. If it's a no, then you're essentially where you would be in any case. So I think it provides a lot of useful things in the event that the independent aesthetics expert determines that they're in a preferred site, but it doesn't change anything if that's a no, because the town can...
It gives nothing to the town, Meryl. It gives nothing to the town on these projects.
Well, I disagree with that because there is language in the town plan that defines what a preferred site is, and the purpose of that language is to say where these projects should be sited.
But you made that town plan now a gray area because you're weakening that town plan.
So what this agreement does provide is a lot of strong benefits for the town in the event that it is located in a preferred site. They're not all directly tied to its status in a preferred site, but if it is in a preferred site, then the town's going to get full releases on all of these other pending claims, and they will withdraw the lawsuit with prejudice within 10 days of receipt of the final report, and they'll agree that no additional projects will be cited on any property that is not either a mapped preferred site or specifically determined to be a preferred site by the select board. So I understand why it appears, you know, really it's defining the pathway forward if it's determined to be on a preferred site, but there's no real loss if it's determined not to be on a preferred site, because you're going to be in the exact position you're in today. I mean, whether the town wants to, the town will then be free to make a decision about what position it wants to take on those projects.
So, Laura, come on up.
They get an unfavorable report from a consultant, a report that is favorable to the town, and the town cannot use that report.
If I may, just to jump in, Laura, just before you proceed. If in fact these are not preferred sites according to the aesthetic expert that is hired, then when they proceed forward, the town will be a party to those applications, and we will be arguing that they should not be allowed because they're not
a preferred site.
But they already know that we're giving up because we're not fighting that. They already know that we don't have a huge amount of money to keep fighting them.
Well, we actually will have, we're recovering all of our legal fees if the town is...
They'll just take you,
we would be able to, we would potentially be able to set aside as a reserve some of these funds in the case that these things do not work out to the benefit of the community?
There won't be, I don't know how much it would be set aside in a reserve. I don't know what the finances are going to be. But the message they are getting, I believe, is that they can and it's obvious, they could bankrupt every town in Vermont, and I think that's their intention, to get what they want. And we know that that's what they will do because that is what they have done. But I just have another kind of question about this part here. Those two sites, as I believe they are, because I drive down Rice Lane all the time, I don't understand why you need an aesthetic expert to say that they are going to be screened by natural vegetation. They are. They're all trees. Isn't that right? All there is in those however many acres for all Battle Creek 1, 2, and 3 is simply trees. Is that right?
No, I mean, there's quite a lot of open land.
Maybe within, but on the margin, which is what counts here, on the edges, there are already trees there. So it seems if that's the town plan definition of having screening, we already know that that's what there is there, except maybe down, well, even behind the public house, I think it's all trees. So in any case, I'm not sure why you need an aesthetic expert to tell you whether that site is all treed in so that it could become the gray area type of preferred site, number one. Number two, why are you going to be using an aesthetic expert when it seems like whether or not something fits into the town plan requires a legal expert? That's a legal definition. It's not an aesthetic definition. I don't understand what, I mean, I've read aesthetic expert reports through the PUC hired by the other side. We don't have money to hire one. And I don't know exactly what their training is, but I don't understand why that was the decision made. Why would you use an aesthetic expert to decide whether something complies with our town plan or not?
Well, it's not necessarily whether it complies with the town plan. The decision, the question that's going to be asked of the expert is, does this meet the definition of a preferred site?
Right.
Is the project entirely screened by natural plantings?
Or the other.
That's the question.
That's the only question they would be asking?
Yes.
Answering?
There's a number of other possible.
Can you say, like, are we looking at our country club? And the impact from those?
Yeah, what about far distant views?
Good idea.
Yeah, don't know.
Can Meryl completely answer?
Let's just, everyone just take a pause. We'll do, Meryl, go ahead and finish your sentence, please.
Oh, I was just clarifying that the page 25 of the energy amendment that's referred to has has several criteria that could be used to deem a project within a preferred site.
Right.
So
well, are they going to be tasked with looking at all the definitions of a preferred site, or are they going to just simply be deciding whether there's natural screening there, or are they also going to be tasked with looking at distant views, because that's obviously a different siting completely.
Just whether it's a preferred site.
They aren't. So what's the point?
The point is to get an independent third party to determine whether it's in a preferred site rather than have to battle that out at the first instance.
But if they have such a narrow definition of a preferred site, and that means therefore that the town will not dispute them and will not fight this at the PUC, then basically you're giving them carte blanche to then say later, well, what about the distant views? There won't be any avenue, there won't be any means to ask any other questions of them if they get carte blanche by this aesthetic expert because they have trees around the margin.
Okay, so I think we get your point. Thank you. I think I disagree with you, but I'm not going to.
Well, that's part of his questions.
So we have a process for getting to a preferred site. What this is doing is setting up a very clear path of deciding yes or no, is this a preferred site, yes or no.
Criteria.
So, and so that's in the as much as criteria as we have is in the solar siting amendment that we did, not to weaken, but to strengthen our town plan, which it did do, because there was no solar siting in it before. So as a result of having the map and as a result of having that solar siting amendment, we now have a stronger plan and we now have a better way of addressing solar. So,
Well, it would come back to our screening plan. I mean, it sounds to me right now that preferred sites, if they're screened, if a site is not preferred, if you screen it right, it becomes preferred site.
If it is already been screened.
So really, it all boils down to a good screening plan. Am I looking at this wrong?
no preferred site can be created by a screening plan. Yeah.
I'm Diana Leeser, so just so I'm clear, what this aesthetics expert would just be looking at is the town's plan with the preferred siting criteria that's already in place.
That's right.
Nothing about distance views, nothing about he or she is here just to address that portion of the plan.
As written in the 2016 version of the plan.
Nothing else, none of the other questions about distance, monument, nothing, just those
That's right.
things.
And perhaps that's why they want clarity on it.
But then you're giving up any way to just find other reasons why.
So Laura, you've had your say, I think. Let's go ahead and give Joe.
Joe Schoening again. You're going to give 3 suggestions on someone that they pick, and they're going to pay the one that they pick. I bet you dollars to donuts that had the Apple Hill neighborhood had the ability to pay the experts that they have used, and we had paid them, bought their services first, what we got from them would have been 180 degrees from what they came out with. Now, I'm not saying people lie. I'm saying people provide a service for their employers. And it seems to me that, I don't know, maybe somehow it would be better if the cost for this expert were shared by both the town and the developer.
We don't want that cost. We want to be able to pick who we want Annette Smith's help to kind of figure out who would be good consultants on this.
Yeah,
who should we put forward as people that will really do a good job of deciding
and at
is
the
this
end of the
preferred
day,
site or not?
that person is going to be paid by the Malones. Why not share the cost?
Because I'm cheap. I mean, I feel like the town we shouldn't have to do that.
Well, that's the problem.
Peter, you had your hand up.
Well, you get what you pay for means something slightly different. I mean, I think we all worry about the influence of money. Absolutely. But I also have to believe in the integrity of experts. I mean, the way the business of environmental experts work is that your work, is your reputation. It's the same in any field. And this, it does seem, if we came to you and we said, okay, we're going to choose the expert and we're going to pay for it and they're going to get the results of it, I would hope that we'd be a little concerned about it. I mean, I've got to believe that if we hire a professional, if we put forward professionals that we believe will give us honest answers, we're not going to find people that we think are going to be in our favor and be opposed to the other. We're looking for people who actually will render an honest answer.
But you won't be if I could just add to that, I've been up at the PUC and I've talked to a number of people who've been involved in all these hearings. And I don't have direct proof of this, but I've been told. In fact, I was just told this yesterday by an attorney that I'm working with, that the experts are very aware of who pays them. So it won't be the town that's paying them, it will be the Malones that are paying them.
But it's a different situation, Laura. It's not that they're going out and finding that person and saying, I want to pay you to render this. They get the money whether they're in favor or not in favor of it being a preferred site. So it's a very different situation. I agree. If I go out and I hire somebody, I'm really hopeful that they're going to vote, that they're going to they're going to decide in my favor. I mean, that's why I'm hiring them. We are hiring.
No, you're not.
Yes, we are. We're hiring, so the town is making, the town is saying, these are 3 people that we are willing to put forward that we believe will be honest brokers in this case, and that their decision will be an honest decision. Whether the money, I assume the money gets, I don't know, the money's in escrow or something.
No, it's a contract with the consultant. The contract is required to state that the consultant is required to exercise his or her independent judgment when performing the aesthetic analysis. And I'll add that this is a different scenario than when you hire somebody to present evidence for you in court. This is hiring somebody to basically settle a bet. I mean, say yes or no, yes or no. We're not trying to put them, we're not trying to present them as a witness at a hearing.
But it might be. It could be.
That's not the purpose of this. That's just not the purpose of this particular hiring process. The hiring process is, here's the information, here's the town plan, yes or no, up or down. And the parties agree that the final report is work for hire for the developer, and they have the sole discretion as to whether or not to file the final report as evidence. But that doesn't mean that they can tell the aesthetics consultant, now you have to come testify for me. That's not going to be part of the contract.
But Merrill, it also doesn't say that the town gets a copy of that report. That's something that should be in there too. But I do have a question on this, because I am a little confused on the criteria for preferred site. Under the language now in our town plan, is the only criteria for being a preferred site aesthetic considerations?
No, there are several.
That's what I thought. So therefore, now here's my suggestion. Putting in here 3 names of aesthetic consultants limits what gets analyzed for a preferred site. A site may meet the aesthetic requirements, but not meet any of the other high bar. But you've limited what the consultant says. So I would suggest that in the negotiations, the reference to aesthetic and aesthetic analysis, aesthetic consultant, aesthetic analysis, that the word aesthetic be taken out, and it'd be 3 consultants who would give a report to both the developer and the town regarding whether the projects meet the criteria for a preferred site or do not. That's something. And if the developer says, no, we won't agree to that, that's a problem.
If you look at the other criteria, I mean, it's pretty evident on the face of them that only a couple of them would even apply to getting this into the preferred site category. So that's part of the reason why this particular type of consultant is specified.
Well, what this does is it limits what the consultant does to just aesthetic concerns, and all the other criteria can be ignored.
Noise, wind, blah, 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 blah.
I'm sorry, yeah.
Noise, wind, etc.
Yeah. The final thing is, somebody made the comment about, where we're coming here from. I'm not sure in an agreement that resolves litigation regarding the Chelsea project and the Apple Hill project why there's any of this other stuff that's in here, although I do understand why the developer would want that, because it smooths their road out tremendously. But if you can't get them to make those changes regarding, 8, 9, 10, 11, 12. 7. No, 7 refers to Chelsea, and so does 8. And 9. Yeah, so it would be 8, 10, 11, 12, the rest of it. Why have them in there at all? Because they only give something to the developer, and those things give absolutely nothing to the town. And they undermine the town in some ways. And if it's true that this language allows them to limit the consultant's opinion to just whether this is a preferred site based on aesthetics, the town's giving up a huge thing. So Those are my comments.
Mayor, I'd like to make a suggestion that I think goes right to the heart of this, and that is with respect to any of these aesthetic analysts. They shall put language in there that says that they shall have had no prior business dealings with the developer.
Yeah, that's going to be part of our vetting process.
We get to decide.
Yeah, we get to decide.
Yeah, but that's not in here.
No, but we get to choose those three. Yeah, so
Yeah,
I
we
think
choose them, so, I mean, it's first question.
we might not want to limit ourselves. I mean, I get where you're going, it's a good idea, but we might not want to limit ourselves because there might be somebody really good that would come out with, you know, that we think would really give us a fair answer that might have had some business dealing with them. Maybe they went against them or something. Anyway, that's where you're going.
I'm kind of confused here because it says the developer gets to choose.
We would only put four
Of the
ones.
three.
Three people we identify. Yeah. So we pick three, then they pick the one they want. So we can do the vetting at the outset.
Before we move on, can I ask you a question, Ron? Relating to some of Peter's comments, in relation to, you've been obviously the conduit back and forth between the Malones and kind of us in this, collective sense.
Right.
Hearing things like, just for example, the one Peter just brought to bear, and you mentioned earlier, kind of knowing maybe the way the wind's going to blow a little bit. I don't know how you said it.
Weather report.
On what?
Well, how if we were to go back and say aesthetic and other considerations, for example, would that upset the vote? So it's difficult to say just go back and keep fighting. You know what it's like to second guess somebody else's long, hard negotiations,
But I made
right?
a suggestion
So,
about what you could go back with.
I know, but so she's been negotiating this for a long time, and we want to get it right on the one hand. On the other hand, there's real reason to believe that we need to seriously consider this right now.
I just want to finish. Hold on, I have
I'm sorry,
a couple more points. No, it's fine. I'm not worried about it. I think, obviously I took a lot of notes here, but a few of the comments that were made, I relate to Peter on a couple of these. They don't seem earth-shattering in the sense of, what we're asking for, but they do, if they're turned down, they kind of bring the hairs up on my neck a little bit if they're completely opposed to them. And so that's kind of one question. Would you agree with some of the comments? I mean, I could go through each one of them that Peter brought up that don't seem as large as others, just to kind of get a little bit of a test on.
Can we do that at the end, do you think? I mean, I think that's the question, going to be the question in front of us. But I do feel like let's get through. So thank you, Carson. We do need to wrap this, but let's get through the rest of these numbers, and then let's go back and look at our highlights and see if we can live with them or not. And then that will be, I think, a way forward for us. So, sure. Please come to the mic and identify yourself. Oh, and actually, never mind. Just say who it is. Which one is it?
I don't think you're going to pick up on that one.
Thank you.
You just said that Merrill had been negotiating this for a long time. How long has that been?
Oh, not that long. It depends if you count in hours or days, right?
How long?
Yeah, the duration, I mean, we wouldn't have had any conversations until that vested rights decision came down.
Okay, so after August 30th.
So if you're asking about specific dates, I can't tell you. Largely it was last week.
Okay, that's fine.
I overstated that for
I'll speak
sure.
loudly enough. So the board got this document on Monday night.
Would you identify yourself?
Joey Falcon, Bennington. Do you feel confident, each of you, in the 36-hour sense, voting on something that you haven't had a lot of time to digest, let alone all of these folks? Chad, you're a football coach and a teacher. You've been so busy. You have a game plan for Friday.
I do. You're right.
How many hours have you been able to devote to this? Jeannie, you run a college. Jimmy, you have a job. You work at the hospital. Gene, when you hire a principal on 36 hours notice, I'm just asking if you are ready to make a positive vote on this if you just got this 36 hours?
Thank you. We'll find out. And
Yeah, Joey, that's sort of what, that's why we're having, that's why we want to hear from the public right now.
The board, you must digest this all in your own private, personal time to understand more of it.
And it is very true that we rely extremely heavily on the advice of our counsel. So we are not lawyers. We are not professionals here. We believe we have hired the best law firm available to represent us in this situation. And we depend incredibly deeply on their recommendations.
But the town of Bennington depends on all of you
We understand
to
that.
digest this and make a decision based on what's best for the town
We
of
understand
Bennington,
that.
not on a firm's decision.
We
expect
count on
you
them to be our
dissect
consultant,
and
right.
make a decision based on what's best for the town of Bennington.
So
Good.
I would love to hear if there are any more comments.
Okay, yeah, so where are we? Are we so 12 runs
2 pages.
2 pages, but it's what we've just been talking about.
Well, I guess I didn't hold out.
Okay.
I have a question here.
On which one?
That's on, are you on 12?
11 and 12.
We'll pass over.
Since we all know that according to the town plan, Battle Creek 2 and 3 are not preferred sites, why are we doing this? Why is this in here? To allow somebody else to decide that it is a preferred site?
So
I don't get it.
The way the town, Rick was involved in this, Mary was involved in this, Jim was involved in this, Michael Keane was involved in it. Anybody else? We spent a long time writing a solar ordinance. It was crafted over the course of 6 months or more. It went through several iterations with the Planning Commission and the Select Board and was eventually adopted into the town plan. And that came not only with the map, but also with all of the details that came with the solar siting, as you know. And baked into that solar siting is both a set of preferred sites, which are mapped. So that's one area. There are mapped preferred sites that we identified.
Yeah.
And incidentally, if this was signed, those would be the only sites that would be eligible for this company at some point in the future. But we'll get there. So we also set up parallel to that, which was baked into the same piece, a process for deciding if something was a preferred site, even if it wasn't mapped as a preferred
Right,
site.
I understand that
Okay.
part, and this gray area as was described. But I assume that when that language was put in, it was made with the assumption that the town itself would make the decision about whether these kind of gray areas that have screening would be the decider. So, I don't know, Stu's office or Dan Monk's. I don't think it was intended that to allow developers to get involved in whether or not it was a preferred site. And if it hadn't been assumed that the town itself would make that decision, then maybe there's something wrong with the way that was written. In other words, if we need outside experts always to come in and decide on these gray area sites that have natural screening, is that what's going to be happening for everybody? Or are we giving the Malones a special present here because they're such good guys?
No, it's not. If it truly is a preferred site, if it truly is, and say however we choose to define that, then according to our existing town plan, there would be the ability to put solar development there. If it truly is, but if it's not, then there would not be. Now, let's play this out a little bit. Suppose the aesthetic or the multi-disciplined consultant comes back and says, no, this is not a preferred site. Then they would still, unfortunately, and we pushed hard to try to have this changed, they would have the ability to come back and not only challenge everything, to challenge the solar siting, to challenge the new town plan, to challenge Act 174, to challenge everything.
They're already doing that, as we know.
Yeah. So
I think the question that she has is, when you put the gray area in the new town plan, for anything outside of the proposed preferred on the map,
Yeah.
are you going to have these people come in and assess whether that is a preferred area or not, or is it just the Malones who get to do that?
Yeah, no,
Or do
I don't
you
think that was the
get to decide
intention. To be
what
honest, I don't think that was the intention. I
So
think,
you guys got to decide whether it was going to be a preferred
I think that's
site
right,
or
and-
not,
and I would-
except the Malones get to do this type of arrangement.
well, I would say that
For
as,
these two.
it is a negotiation and it was a concession, but I would
That's what
say,
you're trying to point out.
but, well, I agree, it is a concession, but at some level, what I think they're trying to do is get to clarity through, they want to route to clarity through the process, yes or
But
no.
that's the point of that whole Act 174,
Mm-hmm.
which, as I understand it, was to give the town the right to set up the criteria for preferred sites, and then presumably be the deciders based on the criteria, just like everything else is decided, zoning and whether you can allow solar projects in rural conservation districts or not. All of those decisions are made by the town. You don't hire an outside expert to come in and help, typically, I
That's
don't
right.
understand.
I agree.
And that wasn't the intention, so why is this being done? Whose idea was this? Did they want this, or did you want this?
Let's let Merrill answer.
Well,
It's a compromise. I can tell you it's a compromise, and I can tell you that it's tied with some very serious issues for the town that are dealt with in the event that the aesthetics expert says it is indeed a preferred site. And those very serious issues concern other litigation that has been raised, and having a very clear understanding of how a path forward to getting those other issues basically finally dealt with. So it's not a standalone provision. You have to read it in conjunction with the paragraph 12 benefits to the town. You know, the town has the right to push back on the preferred, you know, if it's not a preferred site, then the town has the right now to challenge that project. This is just one way to define, in connection with this compromise, one way to say how that decision is going to be made. It's eliminating a variable. It's allowing folks to say, okay, if this, then this, if this, then that. It's not intended to be, you know, it's not intended to be anything more than a definition of how things are going to proceed.
Well, I'm still trying to understand, are you saying that they were not willing to allow the town staff, as they usually do, to make these decisions?
No, that is not what I'm saying.
So therefore, you were willing to give up the town's authority to these outside experts, you know, to hire an expert, to make the decision about what fits our town plan's criteria for a preferred site?
No. The answer is no.
But isn't that what's happening if you let them hire somebody to make that decision and write that report?
Make a decision.
I feel like you're interjecting. If Laura has the mic, let's
Well,
take the appropriate
she's
turn.
trying to clarify what I'm saying. I think we're on the
We should all
same.
have the courtesy of going to the
I
microphone
don't
to
know if she
identify.
has any offense to what I'm saying, and if you
We have
can, in any way,
procedures.
shape, or form, that's an appropriate site there.
okay, so I'm sorry, I'm lax on this. I would like to ask everybody that has a comment to please come to the microphone when you have your comment. So Laura,
Well, I'm trying to ask what I think is a simple question, which is, why is the town giving up its authority to make the decisions about what's a preferred site or not? And I can understand negotiations. I can understand giving up something. If you're going to tell me, well, you had to give that up, you had to allow the town to say, we're not going to make the decision, but we'll hire a referee in order to get these other benefits. I can understand that, but that's my question. Is that what happened?
Not exactly. I'm not going to go into a lot of detail about settlement discussions and the specifics of settlement discussions and what happened when, but I can tell you that the town's not giving up its authority to make this decision. It's delegating that authority for a very specific compromise, for the purpose of this very specific compromise in this very specific instance. And
I am satisfied with that.
Okay, I can't ask my question to get any more clarity, I guess. So I guess
Would you like to come to the mic and take a shot
I'm
at
not
it?
sure,
or-
if I speak, I prefer not to go to the mic, but thank you.
Identify yourself.
I have a big enough voice, I don't need a mic.
Okay. Well, so we are winding down here. We are still. We have heard comment on the preferred site issue. I think we've heard our legal counsel's opinion on it too. We are at 13, as I reckon it.
I'm sorry, I just am
Go ahead.
confused.
Yeah, go ahead.
I'm really sorry. So I'm still Diana Leeser. And so when you were talking about, you said that this negotiation, this part was being negotiated because of, I'm trying to figure out what you said. So this thing is being negotiated this way because of other legal matters that have been raised by the Maloney's. Is there been additional lawsuits that they've threatened, or, I mean, you said you were going to comment on other litigation. It sounded like to me there were more things tied together than just this one negotiation for this one project.
Well, I didn't say that this was negotiated because of that. I said, or if I didn't say, I meant to say that it's tied in to this as not, it's not a, it all comes together. It all comes together. And I also didn't say that I wasn't going to comment on other litigation. I said I wasn't going to comment in detail about the settlement discussions, specific settlement discussions. The litigation that is being referred to is already pending. It's already out there. It's the lawsuit that has been filed in several courts and is now pending before the Vermont Supreme Court for a decision about jurisdiction.
Okay.
So it's nothing.
This negotiation, this specific aesthetics portion of this settlement, does that have anything to bear on any other litigation that's either ongoing now or that has been floated before you were the board?
I mean, I would say that this entire agreement does. This is all wrapped in, and there's a reason that it's all wrapped in so that there's clarity on multiple fronts. And some definitive answers on multiple fronts. I mean, some of it is
but not specifically with this aesthetics expert portion of it.
The whole thing is a
series of
negotiated
compromises.
compromise. Okay, so it's a negotiated compromise that, so we do not want to be in a situation to opine on what our legal position is right now. But if we thought our legal position was not secure, it would be in our best interest to work as hard as we could to get as much as we could out of a bad situation.
Well, and whether or not I'm also not going to speak on our feeling about our legal position, but regardless of our feeling on our legal position, we all know the potential for costs and time that come along with significant litigation in other fronts. So regardless of how we assess the risk and the likelihood of the outcome, the reality is it's exposure, and it's exposure at the very least to the potentially significant expense of defending those suits.
Isn't it worth another 358 discovery requests? Chad, when your football team is, you're going to be good one day, and when your football team is down 40 to 8.
Well, we're good now, but thanks for that.
When your team is down 40 to 8 in Fairhaven in the fourth quarter, 8 minutes to go, and your boys are tired, what do you tell them? Hey, don't worry, let's just take it easy for the next 8 minutes. Or do you want to play every single play until the final whistle, regardless of the final score?
So the rhetorical question, thank you, Joey. Where are we on number 12? Where do people feel like we are? I want to get through this list.
Here's a question that I have on that.
On number 12?
On number 12, which
Okay.
is tied to 10 and 11.
Come on up to the mic. I would remind people
Well,
again.
I'm sort of right by it.
Okay, all right. Well,
the Stark and the Warner projects, nothing's been filed on them, right?
Well, technically, you mean filed where, I guess is the question.
Public Utilities Commission.
Yeah, they're power contracts for those projects.
Well, they got the power contracts. That's different from filing.
Well, but something's been filed, so the answer is yes. But
there isn't a proceeding yet, as
correct.
I understand.
That's correct.
Okay.
Yes.
So why have in this agreement the town tie its hands in any way without getting anything significant back regarding those projects? Why have anything in this unless you're going to get something significant back, such as if they're not preferred sites, then they won't develop them, then they'll go away. Without something that the town's getting back, I don't see any reason to have any of these references to the Stark and Warner project, and they do give a little more because you're agreeing to reduce setbacks on the two projects, you're agreeing to other things, you're agreeing to actively support their projects. So that's if it's a preferred site. But if they're not preferred site, you're getting nothing. And this doesn't settle anything regarding those projects other than give the developers a big leg up. So why have that in the agreement? And again, maybe this is something that the developer insisted on. I can understand they're wanting it because it benefits them. But it doesn't benefit the town. And I don't see how the town can agree to something that includes things, doesn't give them any benefits, doesn't give us any benefits, and gives them a lot of not only protection, but a big boost.
Thank you. I think we have that point. And I do feel that there are things in this agreement, and I think the board, I feel that there are things within this agreement that we did want. And I feel that it was a negotiation that we, maybe not in this particular section, maybe that was a concession, and she's not going to talk about that, but there's a give and take to a compromise, as you know. So, but your point's taken, we got it. We're going to move on. We're going to move on to 13.
Well, Don, what did the town get in this agreement, other than the payment of $202,000?
Well, there's limits on damages claims. There are limits on where they could ever do a project again. In my mind, this project puts them in a box. It's true that they get through these couple of other projects they have, but after that, it puts them in a box. So it feels to be, I mean, how long do we want to keep fighting with these people?
Long enough to protect the town.
Well,
they won't stop.
With whose money?
You think they will stop?
With whose money?
If you don't mind my saying so, when they first compromised, that
Country Club's money?
Everybody thought that would save the town money by caving to that, and that didn't work. They will not stop.
Okay. So, is there anything else, 13, 14, 15, 16, 17, that people want to talk about? 15. Okay. Would somebody pull the mic over to her again, please? Thank you. I'm sorry to ask you. Thank you very much for doing that.
It's all right. Bill's on the map.
Could you actually explain what that means? And it says reasonably required.
15, Meryl.
15.
Sure. Yeah, this is a relatively boilerplate provision, and it basically means that if there are other acts and things that have to be done in order to effectuate the purposes of this agreement, that those things will be done. And so essentially it's saying if we have to sign such document, or we have to give consent to somebody to disclose information, or if there are specific things that are necessary to effectuate this, that everybody agrees to do that. And the reasonably required language, it's also typical language that basically says it doesn't mean everything under the sun. It means what actually, within reason, is required to get it done.
But the way it says additional agreements, does that mean it can be more agreements than what's already probably going to be agreed upon in this draft?
it would be agreements that are required to affect the purposes of this agreement. This is language that would contemplate something, you know, for example, the contract that needs to be entered into, that would need to be entered into with the aesthetics consultant, other things like that that are required simply for the purpose of carrying out what has been agreed to in this.
What is reasonable?
That's always that's a very good question.
Right, that was my point. Reasonably can be defined very differently depending upon who's defining it.
That, I agree with you.
So why is it there?
That's how the, yeah, it's how.
I'm so sorry.
If I could define the word reasonably for everybody, I would, I don't know, I'd be.
You'd be on the Supreme Court.
Yeah, I would be.
Yeah, what's reasonable then?
But it is a very common legal term that's used all the time, and unfortunately, as nebulous as it may seem, that's just that's a term of art.
Do we have consensus from the legal arms in this room that reasonable seems like it's supposed to be there?
Yeah, I mean, it is what Connolly has put in there. Courts have defined reasonable. Now, judges may be all over the place on that, but it happens all the time.
Yeah. Thank you.
Ultimately, the final court, the appellate court, will decide whether something is reasonable or not.
And notice that it says reasonably required, not reasonably requested or demanded. It's required to affect the purposes of the agreement.
Okay, I'm going to say that the boilerplate elements of this, the last parts of this, are not receiving a lot of disagreement. So let me just ask the board, does anybody need a 5-minute break, or do we push through?
On the break.
Can you push through? Push through? If you need to.
No, it's okay.
Sorry. This is for your health.
Okay, so we are at a point, Meryl, where I think the board has heard public comment, and some really good points have been raised. I think if I could summarize, I think, you know, we have heard a very compelling case for why a settlement agreement might be a good idea, but we've also heard some compelling things about this settlement agreement. So, you know, we have a motion on the floor.
Can I comment at some point on that motion?
Absolutely. So I was just going to ask the board how they would like to go forward, picking out how you'd like to go forward. So if you have a comment on that, I'm all ears, Carson.
Well, it's my motion, second by Chad, is that right?
Mm-hmm.
So just as far as procedure goes with this process, so we vote up, we vote down. But if I want to modify or change, when would that process happen? Where in the process would I interject that?
You can.
Excuse me. It may be worthwhile to call for a deliberative session so that we can sit with council and talk about potential changes.
Okay.
That's what I was looking for.
Your motion.
Okay.
And then have more discussion and make a new motion. You can withdraw it.
So can we motion to withdraw?
Okay, so you can or you don't have to. We could ask to sit with council. We could ask to go into an executive session?
It's a deliberative
session with our council and talk about some of these possible legal issues that have come up.
Maybe helpful if we find another room rather than everybody else.
Okay. All right.
So we need to motion
why don't
to withdraw?
we meet in the men's room?
There's a faculty lounge on the corner. Take that
Which way? This way?
Yes. And a bathroom.
Okay, so are we doing, Stuart, are we adjourning or are
we're entering deliberative session?
We're entering deliberative session. We'll head.
Do we have the motion?
Do we have a motion? Okay, I'd like a motion to go into deliberative session, please. So moved. Second. All in favor?
Yes, we'll be returning.
Okay.
She's asking.
You can go right up here.
John, are you coming back to make a decision tonight?
We will be coming back. Okay, so we are coming back after a deliberative session. I'm going to take the liberty of allowing one technical question from Mary Morrison.
Okay. My question is, the notice was put out that this meeting tonight would be about Chelsea, and other related matters. The people that are in the area of the Stark and Warner properties basically were probably not aware that they were going to, and there is significant language in this proposal that regards to them. So they have been left out of this public process, which is not a good thing.
We did actually send notice to Harvard Hill and the public house.
Okay.
Thank you, Mary. Okay. Chad? I mean,
Chad, you mean
I keep
Carson?
calling you Chad, but it's Carson.
I wouldn't last very long on the football field.
No.
Sorry. So I'm going to first, and if I don't follow the correct procedural process, just chime in. I'm welcoming of that. I'm going to retract my first motion, which was to essentially vote based on the current...
You don't have to restate it. You just retract the motion. Yeah.
Okay. Retracting my first motion. Do I have a second?
Second.
Okay. So now we have a clean slate.
We have a clean slate.
Okay, great. So I'm resubmitting my motion to accept the settlement agreement as written, subject to the following changes. And if you want to follow along on these changes, I'll be just kind of highlighting it based on the numerics that are next to the kind of the different sections here. So in section number 1, we are planning, we're doing it under the change of following the words Chelsea project, we're going to exclude, and the Chelsea project is consistent with the town plan in effect in 2014. So striking that. Going down to number 7, we're adding subject to clarification that this does not waive legal rights of others. Okay. Number 9, clarification that the town will not require dark sheathing on the fence if other parties choose to waive. That relates to number 9. And then in number 10, copy of the report will be provided to the town. So those changes come in the context of the settlement agreement that was offered.
I'll second that motion.
Okay, so we have a motion, we have a second. Is there, before we take discussion, Merrill, is that a complete rendering of what you heard in our deliberative session?
Well, I'm not going to comment expressly on that, but I am going to say that I just want to clarify for everyone that a vote on this motion doesn't necessarily mean that a settlement agreement will be signed with those provisions. It means that essentially we're going to say that the settlement agreement would be signed by the select board if those things are adopted. So I just want to make sure that everybody's understanding that it's not a guarantee that a settlement agreement will ultimately come out of that with those changes.
So it's possible that we could lose all.
Right.
But we can be hopeful that they will seriously consider
those changes, yes.
Our requests.
So I just want to make that as a clarification. Just so everybody understands what sort of what the process would be after this. So, and I guess the point is that the changes aren't entirely at the town's discretion.
Could you clearly though state that again how this will work? So if they agree or say they don't agree with any of the amendments, then we're back at square one?
All I can say is I don't know where we'll be. There's no guarantee on that.
We might have no agreement. We might not ever get to an agreement.
But
we're going to roll the dice.
Language that they put forth that you want to consider when we do a process like this again.
The motion right now is that we will approve this if they will make those changes.
Excuse me, what was number 7 again? What was that?
Happy to. Subject to the clarification that this does not waive legal rights of others. And this, kind of in a broader context, relates to the Apple Hill Association.
Legal rights of others.
Others.
You folks. Us. In other words, us.
In this,
this is not necessarily the legal language that will be used. Okay.
Oh.
This is the sense of yeah.
So this is not the actual language that's in the
It'll be.
Because basically it doesn't make sense.
You understand the purpose of what we're trying to accomplish there?
Yeah, the clarification is that this isn't intended to have any impact on anybody else's legal rights that have nothing to do with this agreement. In other words, it's clarifying that the town, by this, is not intending to waive anybody else's rights, whatever those rights may be.
So Seth is saying as is with both of those statements in there with that addition.
With an addition like that, that's right.
And there was, what was the one after that?
Number 9, could you repeat that?
Sure. Clarification that the town will not require dark sheathing on the fence if other parties choose to waive. And that was in respect to some of the comments that were being brought to bear on the concern of black plastic boxes being seen on the hillside. So we wanted to ensure that kind of if other parties chose that they were unsightly, the town will not be kind of in opposition of those individuals or groups.
How will we find out ongoing what?
I don't want to pretend I can answer that.
Meryl? I don't quite understand the question. I think it's how will we find out what's ongoing is the question.
No, what are the next steps? Yeah, if they agree or not.
Oh, I see.
Yeah.
You know, I honestly could not answer that right now.
We don't know if they'll even consider this.
Yeah, I
But
don't know.
if they do accept,
If they do accept,
could we ask Stuart to do a press release if they accept the terms as
Yes.
is?
Yeah.
Yes.
We'll get the word out.
So get the word out, haste post haste, if they do accept. Yeah. Okay.
You accept the impact of the public meeting?
No.
No, we don't need to.
If they
So-
accept all of our terms, right.
Then we're set. If they don't, yeah, if they counter or if they don't choose to entertain this at all, then we don't, I mean.
We don't know where we are.
We don't know where we are.
And,
Yeah.
and we can't, and we shouldn't speculate
Yeah.
right now.
Yeah, you're where you are now, proceeding with the legal proceeding.
Exactly.
So, okay, so are there any other comments from the board? If not, I'm going to call a vote.
There was one other comment.
Could you clarify number 10?
Yep, there was some concern in relation to, actually, you had mentioned it, Peter, was the town being provided a report, you know, and whatever comes out of, from the consultant, who he or she or whomever that company may be.
We want
to ensure that we have access to a copy of it, and I think you brought up an incredibly valid point, you know, shouldn't be confidential.
That was understood, but because it's understood, I don't see any harm in adding it.
Hopefully we get that one at least.
And there's nothing added to this about what happens if Stark and Warner are determined to be non-preferred sites.
No,
I understand.
that's right. That's right.
And there's no clarification that it's only limited to aesthetics rather than all the other criteria.
So no, when you look at those criteria, when you look at those criteria, we believe that this aesthetics will make sense. There is no, it doesn't make sense to have any other kind of consultant in there. It's that we decided that that was not a hill to die on. So you look at them and I think you'll agree. So I do. Okay, so.
Just asking?
Yep. So I'm going to call a vote. All in favor of the motion as presented and seconded, please indicate by saying aye. Aye. Opposed? Okay, the motion is carried. Stuart, I guess I would like a motion to adjourn.
Was it 6 to nothing?
6 to nothing, yes. Unanimous motion to adjourn?
Donald, weren't you going to make some final remarks?
I was, but I'm not going to.
Thank you.
I have a book of final remarks I'm not going to make.
So is that going to the Malone's tomorrow morning?
Okay, all in favor? Aye. We are adjourned.